1554 by my father, my lord. And out of that, a part of the land has been acquired, my lord. So, my lord, the compensation is about to be given to the other side, my lord. It was released to him, my lord. And thereafter, my lord, on our complaint, my lord, the amount has been returned back to the authority, complaint authority, my lord. And thereafter, my lord, he filed this writ petition claiming that the amount will be released to him, my lord. But in that writ petition, my lord, incident writ petition, he don't make us as a party, my lord. So we make a case for impleading.
Madam, tell me, how are you maintaining this situation? If any amount is there, any difference is there, go over there, whoever, why you are not approaching? Have you approached under section 12? And this is acquisition done under what provision?
Under National Highway Act, my lord.
National Highway Act. If it is something out there, why you are not approaching the authority concerned?
Yes, my lord, we have made an application, my lord.
Then the authority should refer it to the, then have you moved the competent authority?
My lord, we have moved, but since this petition is pending, my lord, here, my lord, so we have not made a party, my lord. It may affect us, so that is why we have filed this
Lordship, the
IF for
amount
impleading, my
was-
lord. Otherwise, there's a mutation case of mutation.
Lordship, the amount was already disbursed to us, Lordship. The amount was already disbursed to us, Lordship.
You
Then-
got the money?
Yes, it was with us, Lordship. Then we were under coercion and it was not within our knowledge. We were forced to sign, which may be seen in Annexure 4, page 28.
Yes.
In the IF, my lord, at page 22, it is there, my lord.
No, it's okay.
Lordship, this
Page-
was,
Page 22 in the IF, my lord.
No, you got the money.
the money was with us, Lordship. Thereafter, we were forced by the police officials and these people forced us to sign a document, the contents of which was not known to us, Lordship. In that document, it was written that we will return back the money. We were mentally harassed, Lordship. Thereafter, on 29th, after 2 days, when we came to know that we were forced to sign this, then we voluntarily went to the department to say to the department to return back the money, and we have returned back the money to them with us, and they have also issued a certificate to us that as and when the things will be resolved, the money will be returned back to us. And now we have approached them for our legitimate amount to be returned back to us, but it is not done till date, Lordship. Thereafter, we have approached this court.
Who is the competent authority?
Lordship, we have written to the additional deputy commissioner and they have also filed their affidavit.
Who is this? Yes.
Affidavit is already filed.
Yes. What is your stand?
Same stand as taken by my landed finance. That
Huh?
due to pendency of revenue appeal, my lord, that disbursal amount has already been.
And
returned
since
back.
our name was reflected in the mutation, they filed a mutation case which was rejected and they went for appeal.
That it is there.
Take a lordship to page number, my lord, the IA page number 12, my lord.
No, a national highway. Now, if there is a dispute, who has to get it? Can you decide?
It has to go to arbitration.
If you go to my lord, this 3H, my lord, 3,
Kindly see 3H.
3, my lord.
Yes, ma'am.
These matters shouldn't be pending. Kindly see 3H.
3, my lord.
3H, if there is any, where there are H3,
Yes.
where several persons claim to be interested in the amount deposited under subsection 1, the competent authority shall determine the person who, in its opinion, are entitled to receive the amount payable. If any dispute arises as to the apportionment of the amount or any part thereof, or to any person to whom the same or part is payable, the competent authority shall refer the matter to the principal civil court of the original jurisdiction within the limits of whose jurisdiction the land is situated. Have you done that?
As for affidavit, it's not
Then
reflected.
why haven't you done that? These are matters not to be resolved by this court. Why haven't you referred it? Within 15 days, refer it.
Fine.
I'm passing the order disposing of both the applications. Not necessarily, because these can't be decided by this court. I can't do. The instant application is being filed, take it on to do.
Yeah.
File, it I cannot A alam na. A alam,
G alam.
G alam. I will take it the petition. The instant application has been filed by the applicant for being arrayed as a respondent in the instant writ proceedings. The reason for filing the instant application is that the applicant claims to be the owner of the plot of land in respect of which the petitioner oblique the opposite party claims the compensation amount. Taking into account the above, this court is of the opinion that for the purpose of proper adjudication of the instant dispute, the applicant is required to be made a party in the a respondent in the instant proceedings. Accordingly, the interlocutory application stands allowed, thereby impleading the applicant as the respondent number 5 to the accompanying writ petition. The registry shall make necessary changes in the records on the basis of the instant order and shall also upload the same in the CIS. I extend this. Now come here. The instant writ petition has been filed by the petitioner claiming, seeking a direction upon the respondents to release an amount of rupees 18,97,400 in respect to the acquisition of land measuring 2 kathas 14 lechas located in Dag number 396 of PP number 5 belonging to the petitioner. Full stop. It reveals from the records that the Ministry of Road Transport and Highways had issued a notification under the provisions of the National Highways Act 1956 for acquiring various plots of land, including a plot of land measuring 2 katha 14 lechas, covered by Dag number 396 of PP number 5 of village Mitili under Hatigor Moza in the district of Jorhat, Assam, for the purpose of four-laning of the National Highway number 37 in the district of Jorhat. Full stop. It reveals from the records that pursuant to the proceedings initiated under the provisions of the National Highways Act 1956, an amount of rupees 18,97,400 was adjudged as the just and reasonable compensation for acquisition of the said plot of land belonging said plot of land. The said amount was duly released to the petitioner. However, on complaint being lodged by the newly impleaded respondent number 5, the petitioner was compelled to return the said amount to the competent authority. This aspect of the matter is clear from the affidavit filed by the respondent number 2 in the writ petition. The dispute, however, in the instant writ petition pertains to as to whether the petitioner is entitled to the said amount or is it the respondent newly impleaded respondent number 5. Now, taking into in this regard, this court finds it relevant to take note of Section 3H of the National Highways Act 1956, and more particularly, subsection 4 of Section 3H of the said Act, wherein it specifically stipulates that if there are any dispute as to the apportionment of the amount or any part thereof, or to any person to whom the same or part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction within the limits of whose jurisdiction the land is situated. Taking into account the statutory mandate, it is the opinion of this court that when there a dispute has arisen as regards the amount, as regards the apportionment of the amount between the petitioner as well as the newly impleaded respondent number 5, which is apparent even from the affidavit filed by the respondent number 2, it was the duty on the part of the competent authority to refer it to the principal civil court of original jurisdiction within whose jurisdiction the land is situated. In the instant case, as the land is situated at Jorhat, it would be before the district judge, Jorhat, wherein the competent authority is required to make a reference. In that view of the matter, this court, in view of the specific provision of Section 3H4 of the National Highways Act 1956, directs the competent authority to refer the dispute as regards the entitlement of the amount of rupees 18,97,400 in respect to the land measuring so and so, what division 2 kata 14 lakhs covered by so and so, to the court of the district judge, to the learned district judge, Jorhat, within 15 days from the date of receipt of the certified copy of the instant order. It is further observed that the learned district judge thereupon shall adjudicate the same in the manner provided under the National Highways Act 1956. With the above, the instant petition stands disposed.
Lordship, it is newly impleaded party number 6. The newly impleaded party will be respondent number 6, Lordship.
Is it 6 or 5? 5.
5 because
5 till 5. It is
No, his IA it is 6
IA
because there the petitioner has been brought in. Na?
opposite.
it's 5.
Yeah.
Item number 3 to 8.
Yes, Mr. Chaudhary, appearing in a matter of impleadment. Yes.
Actually, I do not know why our matters have been tagged along with those matters. I see in item number 3, I think there is a prayer for impleadment.
So there are a lot of other matters. What
Other
is this
matters.
IS for? For impleadment.
But, my lord, we are not parties to that proceeding in item number 3.
Baki kita kyun aise?
Which,
No,
which,
okay. What are the other matters?
other matters, my lord, we participated in an auction process conducted by NRL, my lord, for procurement of, my lord, lifting of RPC.
Then
Now, what had happened, my lord, there were some dispute in the sense, my lord, the quality deteriorated because, my lord, NRL was undertaking expansion. So, my lord, we were hesitant to lift because of the quality. Then in the intervening period, my lord, NRL imposed a ban on lifting. Then they again, my lord, allowed us to lift in the manner, in the process, my lord, the original time frame expired.
there is no IS in the other matters. na?
No,
IS, there are some
Item number
Oh,
3, I is,
okay.
I think, for impeachment of the mother of the respondent matter.
Now let us
That
then
is
take
different.
item number 3 first. Then we'll take up the others. Who is appearing in item number 3? N. Gautam. Yes, you are there. Yes, what is your case? Why do you want to be impleaded?
Lordship. We have, is the
Huh?
mother of the deceased.
Now, what is the other writ petition?
I think that is not connected, my lord.
Let us first, I think, take up item number 3
Okay.
first. Why have you filed who has filed the writ petition?
They have filed, my lord. So we have. What we have filed.
So here, there is an application file. Who has filed the writ petition in this case?
Lordship, They have, they have filed. We
Hmm?
have filed. They have filed. We have filed. Petitioner.
You are the writ petitioner.
Yeah.
You want to implead the mother. That is it. Because the mother is also a class 1A.
I have no objection to that. No,
You are for LIC.
I'm for
Seven.
the respondent number 7, my lord.
What
The
is that?
son has been initially impleaded party. Now they want to implead the mother, my.
Son?
May please, Your Honor. I am on behalf of respondent number
Respondent number
126 LIC.
The
I have
copies has not been served to us, my lord.
Very well. Which one? The IA.
IA.
What are you going to do with the copy?
No, I'm just saying that. I'm respondent 7.
এখন লেখক দে IA খন। The instant application has been filed by the petitioner for impleading the mother of the petitioner's husband.
Yes.
As the respondent number 8. Full stop. This court have duly taken note of the accompanying writ proceedings, which pertains to the claim of the petitioner, who is the wife of the claim of the petitioner, to the entitlement of the proceeds of the LIC policy bearing number 486006062, 486008012 and 444707681. The said claim is made on the basis that the petitioner is a class 1 heir of her husband who expired. Full stop. Taking into account the above, this court is also of the opinion, that the instant application so filed for impleading the mother of the deceased husband of the petitioner is necessary, is in the right earnest, taking into account the claim of the petitioner. Accordingly, the instant application stands allowed, thereby impleading the mother of the mother-in-law of the petitioner, that is Srimati Anju Borua, B-O-R-U-A-H, wife of Sri Jotin Chandra Borua, resident of Jebesor Sankokoti Path, Old Amolapati, PO and PS Sipsagar in the district of Sipsagar, Assam, PIN 785640, as the respondent number 8 to the accompanying writ petition. The registry is directed to make the necessary correction in the records on the basis of the instant order, as well as also upload the same in the CIS. Accordingly, the instant application stands allowed. Now, in the other writ petition, we have to issue notice now. Who is appearing for respondent number 8? Who is appearing for 7?
7, I mean.
You are appearing for the 8 also? No.
Then let the notice go, madam. I'll take instruction.
You are the brother.
I'm the.
You're the brother. What claim you have?
Because the nominee has been, the brother has been nominee and the mother is also nominee in the LIC policy.
You are not appearing, so we have to issue notice.
Yeah.
It will only delay the proceedings.
Then, not,
You are going to appear
yes,
because there is an interim order.
yes.
Ekan lekhibo. Mr. J. Roy, who is your junior? You can accept notice.
Yes.
Yes. Mr. So and so, appearing on behalf of the respondent number 7, further submits that he has instructions to appear on behalf of the newly impleaded respondent number 8. The petitioner is directed to serve an extra copy of the writ petition during the course of the day to Mr. So and so.
Bhavani Sham,
So and so. You want to file affidavits?
my lord.
Who has filed the affidavit? Okay. Mr. So and so, appearing on behalf of the respondent, Mr. J. Roy, the learned senior counsel, appearing on behalf of the respondent number 7 and 8. Mr. J. Roy, no, he's not okay. Mr. So and so, appearing on behalf of the respondent number 7 and 8, submits that 2 weeks' time may be granted to file the affidavit. Taking into account the above, list the matter again on, where is my calendar? Calendar নাই তো। মস্ত এখন বোর্ডত বনাই ৰাখিছিল ন ক'ত এই ক'ত? Ninth of October. The affidavit be filed by 3rd of October, and the petitioner would be at liberty to file any reply by 6th of October. List the interim order passed earlier shall continue till then. Baki kita so.
And I think lordship can detach that matter from this series.
Yes. Yung baki kita so item. Pura.
My lord, in the meanwhile, my lord, NRL has filed their affidavit. My lord.
4, 5, এটা সেই আগৰ petitionখনত লিখি দিব দেই আগৰ অৰ্ডাৰটোত It is also seen from the records that various other petitions, that is WPC number 2273/2023, WPC number 2662/2023, WPC number 2699/2023, WPC number 2702/2023, and WPC number 2919/2023 have been wrongly linked with the instant writ petition. The registry is directed to detag the said writ petitions from the present writ petition.
My lord,
Now, what do you want in
Like,
this
here in
matter?
this case, my lord, NRL has filed an affidavit. My lord.
Hmm.
We'd like to file a reply for which we'll pray for 7 days time.
You want to file a reply?
Yes,
Mr. You are paying for everybody?
all the cases.
Hey, kita baki kita দিব 4 to 8.
4 to 8.
Mr. Kane Chaudhary, the learned senior counsel, submits on instructions that the petitioner wishes to file an affidavit in opposition to the affidavit in reply to the affidavit in opposition filed by the by the respondent numbers 1, 2, and 3. How much time?
7 days. My lord.
10 days time is granted. No, full stop. Accordingly, list the matter again on 11th of October.
My lord.
11th of October. Full stop. The affidavit be filed by, reply be filed by 3rd of October. Full stop. List accordingly. The interim order passed earlier shall continue till.
All the
Item number 9,
My lord, in this case, my lord, IA is filed, my lord, after serving notice to the present incumbent, my lord. who is the Chief Engineer, Public Health Engineering Department. Regarding that, that has not been complied, my lord. That's why, my lord, he has to, my lord, impede as a party respondent, my lord, contempt note number 7, my lord.
The instant application has been filed by the petitioner, by the petitioners, by the applicants, seeking impleadment of whom?
Of depository Dwara.
Huh?
Depository Dwara, my lord.
One Sri Disbursement Dwara, Chief Engineer, Public Health Engineering Department, Hengravari, Guwahati, 781036. In the accompanying contempt proceedings, on the ground that the said person, incumbent, is presently holding the post in respect to which, from whom is presently holding the post, and have been duly informed, seeking compliance with the order dated
10/8/18.
10/8/2018, passed in WPC number 5383/2018. It has also been alleged that in spite of receipt of the communication on dated 19/5/2023, the said Sri Disbursement Dwara, Chief Engineer, Public Health Engineering Department, Hengravari, Assam, have not complied with the order. Taking into account the above allegations made in the instant application, this court deems it proper that the said Disbursement Dwara, Chief Engineer, Public Health Engineering Department, having his office at Hengravari, Guwahati, 781036, Assam, be impleaded as the respondent number 7 to the accompanying contempt proceedings. Accordingly, the registry is directed to make necessary correction of the records on the basis of the instant order and also upload the same in the CIS. I stands disposed. A contempt in view of the order passed today in IAC 2519/2023, whereby a new respondent have been arrayed as whereby Sri Disbursement Dwara, Chief Engineer, Public Health Engineering Department, Hengravari, Guwahati, 781036, have been impleaded as the respondent number 7 to the instant application. Issue notice, making it returnable by 4 weeks. Petitioner is directed to take steps by way of registered as well as usual within 3 days.
My lord, 12 and my lord, 12 and 13 also will be same, my lord. Only the in 12, item 12, respondent number will be 5. And same order in 13 also. Obligation.
Let the file come.
That's it?
Let the file come.
Yes.
Yes. Wait for some
Yes,
time.
yes.
You are in a hurry?
No, happy.
Sit down.
10 and 11.
Yes.
If this application has been filed for a new incumbent lordship. First lordship, as per last order, that 6123. We know that the new incumbent has been come lordship.
My lord, this is a PWD matter I have noticed. So, my lord, I will appear, I am just seeking, sometime I will file the affidavit.
Let us make him. There is no place in place of. The new incumbent will be brought in. Now, prior to that, have you issued notice to him? Have you issued notice to the new incumbent? Then how can you bring somebody? Contempt, isn't it personal?
He has to be given a notice, my lord. So Chand,
Withdraw these IAs, file it properly, give notice. IA Dukanot Purivo, you give your name. The learned counsel appearing on behalf of the petitioner applicant submits that he would like to withdraw the instant interlocutory application and refile the same after taking due steps against the present incumbent. List the matter. Yeah. Accordingly, the instant application stands closed on withdrawal with liberty as mentioned herein above. Take it up to the list the matters after 6 weeks. I dispose. Yes, now come. Your matter? 12. Well,
I am, my lord, 2533. Notice will be, my lord, 28/7/23. Duly received. And he will be impleaded as, my lord, respondent number 5.
Icon sir. Ratakan.
30.
What is this amount? What are you asking for? How much?
These are
amount?
interest amount, my lord.
What
As
interest?
it was, already principal amount has been already released.
Then
That interest, my lord, he is calculating. Petitioner is calculating.
where's the interest?
According to MSME, as he is entitled, my lord, that's why, my lord. Here, my lord, also date is same, my lord, 19/5/23.
Yeah, I got order to do you both same?
Same.
12 and 13.
Item 12, my lord, contempt not will be
That I know.
Yes.
You don't need to tell me. Are item 12 and 13 same?
same. I will like-
Okay, type in notice. It's the same deposit it was. You can notice it. Wait.
Around 14 for admission.
13 I think.
In this paper, they wanted to file an affidavit, my lord. They
Hmm?
informed me. They wanted to file an affidavit also.
Hmm.
So, but I don't know, nobody is present now. Okay, Kayal before me. Okay, pass the entry order.
Why these people have written part heard before me?
Well, I don't know, my lord.
Huh?
For order of. Oh, 26th order, my lord, 26/7 order. There was that on that day. On that day, your losses heart attack, that is why. my
Oh,
lord.
that is the different thing.
Yes, but next day, my lord, it's not heart attack. That is only it.
Wait, who is appearing for the
Sir.
government?
Kayal, my lord, yes, yeah.
They are not represented.
My lord, in fact, well, he informed, huh? Oh, Swami. He told me, my lord, that he has not received the Feroz comment also.
None appears on behalf of the respondent numbers 1, 2, and 3 when the matter has been called for. this court before this court taking into account that a huge amount of revenue is at stake. Is of the opinion that a further opportunity be given to the respondents. Accordingly, list the matter on 9th of October 2023. The interim order passed earlier shall continue till then.
Supplemental is item number 60, 61, part heart. Personal appearance.
This court, this court also finds it relevant to observe that it is not known on what basis the registry has shown the matter to be at part heard before part heard, taking into account that there is no specific orders passed herein that the writ petition have been heard at part by this court.
Sorry, Your Lordship.
নামটো দি দিব Miss R. Deka etu ago ekini kati dibo. Miss R. Deka, appearing on behalf of the respondent, submits that she would like to file an affidavit within 3 weeks. List the matter again on hey 9th of Sakibo, so and so. Atatolot he patharo he order kin likhi dibo.
Supplemental is item number 60 and 61, personal appearance.
The Dinath is appearing, he is on his way, Lordship.
We'll take it up at 2. Ticket logai dibo de 60 and 61. Yes, who is appearing in these two? Manju Bibi and Abdullah Ali. Item numbers
60 and 61.
Oh, these are 60 and 61.
Item number 16.
The court further fixed the treatment.
The Dinath was, you are supposed to.
You have filed affidavit. I have not given personal appearance. It is only said that if you don't file your affidavit, then it is a case of personal. You have filed your affidavit.
We have called for the affidavit, Lordship.
Have you filed your affidavits?
Okay, except I have given for filing, Lordship.
So you have filed it. That is what I am asking you. You have filed. So we'll have it on some other date. And what is the other matter? It is 60, 61 to give. You got personal appearances. Miss, your name?
Miss M. Devi, Lordship.
So and so appearing on behalf of the?
Mr. Dinath, Lordship, on behalf of state respondent.
On behalf of the state respondent submits that the affidavit as directed by this court on 7/8/2023 has been duly filed today. To list the matter along with on 22nd of September 2023 along with the said affidavits. You have filed your affidavit.
We filed the affidavit, we have given the copy.
Item number 16.
Who is appearing? Item number 16.
So I am for the petitioner, Mr. Nath was appearing.
Yes.
That check for 31,000, it is with me, my lord. I have already.
Give it to him. Matter is over.
Look.
And then thereafter, how do you take care of this situation?
But they for the other part, they have given me a bunch of instructions. Kindly give me 2 days time, my lord. Let me go through and I will file an affidavit, my lord.
Okay. You have give the check.
Yes, right now I am giving, my lord. More dear. No.
Mr. Dinath appearing, the senior government advocate, have handed over the check of rupees 31,500 payable to the petitioner to, what is his name? Your name? So and so. Appearing on behalf to so and so, the learned counsel appearing on behalf of the petitioner. Mr. Dinath further submits that he has received certain instructions in respect to the queries so made by this court on 28/8/2023 and would like to place the same by way of an affidavit. So, taking into account the above, list the matter again on 27th of September 2023. The affidavit be filed by 22nd of September 2020.
Item number 62, personal appearance.
We already filed affidavit, my lord, on 7, my lord, could not serve the copy, my lord. Today he received the copy,
You have filed the affidavit?
lordship. We are going to, my lord. It is under process, lordship, the filing.
Mr. J. Hendrick appearing on behalf of the Revenue Deputy Commissioner.
Deputy Commissioner, my lord.
Deputy Commissioner Sipsagar, District Commissioner Sipsagar submits that the affidavit so directed to be filed on 11/8/2023 have been duly filed today. Full stop. The list the matter again on 18th of September 2023 along with the said affidavit.
So, my lord, in the court is, my, it was shown, my lord, the personal appearance. The problem is,
Personal appearance was not.
it is not there, my lord. Obliged, lord.
17,
Yes. Who is appearing for PWD?
PWD has to respond.
Oh, that matter.
My lord.
7 lakh to 11,000. He has done only 21 or 35% of the work.
31% of all.
This is relating to the court premises.
No, my lord.
Which one?
Circle office.
Circle office.
Yes.
Yeah. And then they are saying, the finance is saying that no, we are not going, revenue is saying that there is no approval. Now the
there-
PWD was supposed to do it.
But there is a approval, my lord.
I have seen it.
Administrative Approval
Okay.
39.
None appears on behalf of the PWD on call when the matter call. Full stop. It further reveals on record that on 30/8/2023, this court had directed Mr. Ardhor appearing on behalf of the PWD to obtain instructions. Taking into account that none had appeared on behalf of the PWD, the Chief Engineer, Public Works Department, Building Chanmari, shall be personally present before this court on 22nd of September at 10:15 AM.
Obliged.
18,
Yes, what is your case?
My lord. At least 37, my lord, police report.
You are not interested in the matter.
My lord,
Why you are not appearing from time to time?
my lord. Sorry, my lord.
What is your case?
My lord, at least 37, the police report, your, at least 37, your lordship will connect the at least 37.
Now I advise the word mentioning that during interrogation, the family members of
if the person dies out of his negligence, my lord, out of this, my lord, calamity, my lord, then he is entitled to some financial relief, my lord.
Out of,
Out of,
now,
out-
where are you saying?
My lord,
Let's see the
disaster-
eligibility condition.
my lord, Disaster Management Act, my lord, section 2D, my lord.
Where is it? Yes, what do you have to say?
My lord, I have gotten speaking order passed in this regard. That's me kindly. Private property.
No, what do you say about this one? He's not claiming under 15/11/2014.
Yes.
He's claiming under some disaster management act. Is he entitled that?
That instruction is not received. This is what the order
No, but
passed.
he is not asking any a single penny. Why you have got for the instruction in terms with the other matter?
No, it is in regard to the petitioner itself. That claim has been
Understood.
rejected because
Maybe he may not get there.
Ah.
But where did the incident happen? How did the incident happen? Let's see.
it is within his private property. My lord. He was trying to cut a iron piece of
He was trying to.
Ball-like iron piece of metal, my lord.
Word mentioning that during the interrogation, the family members and local people of the place were using some phone or lens of other completing.
আপনার right?
How are you entitled to this? Give it to me. Yes.
My lord, section 2D, my lord.
Section 2D.
That's 2, my lord. Section 2D, disaster. The definition of disaster, you'll have to be correct here.
No, show me the eligibility.
My lord, in the definition itself, my lord, says, my lord, it means a catastrophe, mishap, calamity, or grave occurrence in an area arising out of natural or man-made causes or by an accident or negligence, which results in substantial loss of life, my lord. My lord,
How do you bring this disaster? Disaster means can't be like that. One single person dying out of an accident, how can that be called to be a disaster?
Well,
Who are
in
the
that case,
people, how is a person entitled to?
well, it is up to your lordship, my lord. The petitioner also submitted an application before the DALSA, my lord, Assam State Legal Service Authority for relief, as the husband of the petitioner.
Where's the crime?
Right, my lord.
Where's the crime?
No,
How do you bring in the victim's compensation?
at least some relief is sought for from the one
No,
half of the
no,
family, my lord, from the government, my lord, as the condition of the family is very poor, my lord.
The instant writ petition has been filed by the petitioner claiming compensation. On account of the death of her husband in the incident which had taken place on 12/4/2015. From a perusal of the materials on record, it transpires that pursuant to the death of the husband, an inquiry proceedings was initiated by the officer in charge, Orang Police Station. And from the reports so submitted, it transpires that the husband of the petitioner was engaged in the business of scrap and what full stop. On the date of the incident, while the husband of the petitioner was busy to break down one scrap article made by copper and brass, he put the said article in the fire with an intention to melt it. But as he put it at the fire, an explosion took place. As a result, the husband of the petitioner died on the spot, and 3 other persons had also sustained injury. It also relevant to take note of that the case of the petitioner for entitlement under the notification dated 15/11/2014 was also taken into consideration by the Revenue and Disaster Management Department, and it was found that as the incident had happened within the premises of the within the private campus, private area, private property of the husband of the petitioner, the petitioner would not be entitled to the benefit under the notification dated 15/11/2014. The learned counsel of the petitioner, though, submitted that the petitioner is entitled to under the notifications dated 27/7/2011 issued by the Governor of Assam, in pursuance to the Disaster Management Act of 2005. But it is the opinion of this court that as the incident which had happened in the case of the husband of the petitioner would not come within the ambit of the definition to within the ambit of the definition disaster as defined under Section 2D of the Disaster Management Act 2005, the petitioner would not be entitled to claim any compensation on the basis thereof. Accordingly, this court finds no reason, finds no merit in the instant writ petition, for which the same stands dismissed. A consent. the order by which the petitioner's application seeking compensation under the notification dated 15/11/2014 was rejected is kept on record and marked with the letter X.
19,
My lord, with all humility, my lord. With regard to item number 17, my lord, I was supposed to appear for my lord PWD in this matter. My lord, when the matter was called, I was in the washroom, my lord. So I could not come, my lord. So a personal appearance, because of my non-appearance, my lord, the personal appearance of the chief engineer's call,
Earlier, I have given you the chance.
my lord.
Then what to do? You have the instructions or not?
My lord, in this matter, my lord,
You have the instructions or
my
not?
lord, instruction is not required. This, my lord can dispose of this matter, my lord.
Why?
My lord, it is almost, if you go by the additional affidavit, there is a chart, my lord, that has been, that the amount they are claiming, my lord, is supposed to be paid. So that is already saved. So my lord will pass a direction. My lord has passed so many directions, similar in similar issues. Temporarily, we will verify and then we will pay.
No. Here is a big problem. Revenue is saying that we are not going to pay as there is no approval. Petitioner is saying that there is an approval and he has enclosed to the additional affidavit.
My lord.
And that is the reason why I have asked you to obtain instruction, and you gladly said on the last occasion that you have instruction. You'll get the instruction. What is the instructions? Have you, the question is, was there any approval for the purpose of the circle of the top? Otherwise, you do one thing, break the bricks, break the building, give it to him,
My understanding.
as well as the labor amount which he asks at the present rate.
My lord, that part, my lord, I'm yet to receive that
So
instruction.
let
my lord.
us, if you keep on making it like a delay it in this manner, why not better ask it from the horse's mouth? That is, the personal appearance is just and proper for that.
My lord, let the horse at this moment remain in stable, but I will put fear in his spine that on the next date it comes, my lord.
Fantastic. Then we'll take it up at 2. Get whatever you want from the
My
horses.
lord will fix for tomorrow, my lord.
Two.
Tomorrow.
Two.
Ma-
Tomorrow, the other person comes. Because I have to change the order. What will the other lawyers think? Oh, this court comes and changes the order at what Mr. Ardhurst dictates.
Okay, my lord.
Two.
Whatever I can bring, I will bring it to my fingers.
You only have to take only one. The additional affidavit, there is a mention that there is an approval. Just find out that. Because the moment I ask them to verify and pay, they will only say that there is no approval and then cancel it.
But it will be, my lord, easier for me, at least if I would go one day, my lord. I would go the whole.
I gave you 7 days. Remember?
That is there.
We'll see at 2. If anything works out tomorrow at 2. Let's see first. Then only people, there's some urgency, otherwise it's not.
Right.
If I had said that if the PWD is not represented, list the matter after 1 week, you wouldn't have come out here.
No, my lord.
No, obviously, you wouldn't have come out here. You have come out here because of the fact of the personal appearance.
No, my lord.
Yes.
My lord, I'll be honest. I will put the.
I only need only one thing. Was there any approval? That's all. Give me an answer to that. If there is an approval or not.
My lord.
If there is not approval, whatever has been done, then you have to restitute the loss which has occasioned to the petitioner, whatever may be the.
My lord.
Or otherwise, because you couldn't have issued a work order upon him if you had no approval.
So, my lord is take 2.
Order to 2.
19,
Please,
Hmm.
I have filed a affidavit in reply, my lord. Affidavit in reply has been filed. my lord.
What? What is this case again?
Ex gratia claim, my lord, due to lightning, my lord.
Due to
Lord,
lightning, my lord.
Can you see your affidavit, my lord?
Lightning of what? Lightning also people get
My lord.
under the disaster management.
Yes, my lord, but he is not get, but kindly see, my lord, page number 38, annexure B, my lord, our affidavit, my lord.
Page number 38. 30?
38, my lord.
38 is not a part of the petition?
No, my lord, our affidavit, my lord.
Oh, yes, yeah. 38. Yes. Paragraph?
The speaking order, my lord.
Okay, page 40. This is by the Commissioner and Secretary, Government of Assam, Revenue and Disaster Management,
Hello.
26/6/2015.
No, my lord, 24th April 2009.
Got it. That is running page 42. Tell me. When you have approached the court by air for payment of excise on receipt of the matter was examined in the light of actual maybe noted that so lightning came only on 26/6/2015
My lord,
and this happened on 27/3/2015. Mr. Counsel, you died later on.
My lord, in this case, my lord, during the pendency of the writ petition, my lord,
Huh?
during the pendency of the writ petition, my lord, they have rejected the prayer of the my lord, writ petitioner, my lord. This is not in accordance with law, my lord. If the writ petition is pending, my lord, they are taking the parallel action against the my lord. I have also filed a reply, my lord.
What reply won't help you?
My lord.
Reply is not going to help you. What you need to do is to challenge this order. 24th of April 2019. You need to challenge this order. That is the only way out. You can't, by way of a reply, challenge this order. Isn't it?
My lord.
So you withdraw, take liberty to challenge this order. That is the only way out.
My lord.
The learned counsel appearing on behalf of the petitioner submits that the claim of the petitioner have been rejected during the pendency of the instant proceedings by the speaking order dated 24/4/2019 by the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department, whereby the claim of the petitioner, whereby with the reason that the rejection was made with a the learned counsel for the petitioner submits that during the pendency of the instant petition, the claim of the petitioner have been rejected by the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department by an order dated 24/4/2019. He submits, therefore, that the said order requires to be challenged for the purpose of requires to be challenged. Under such circumstances, the learned counsel submits that he would like to withdraw the instant writ petition with the liberty to refile by challenging the order dated 24/4/2019. Taking into account the above submission, the instant writ petition stands closed on withdrawal. However, liberty is granted to the petitioner to refile by challenging the order dated 24/4/2019.
21.
This is the quota for the non-payment of compensation amount for acquiring the land for expansion of the pole and in the Kopur. What happened?
What do you want?
My lord, in this
Acquisition
acquisition, my lord, already my lord,
34,112,785. Why haven't you received it?
my lord, here only my lord, the 11 lakh yet to be paid, my lord. That is admitted by the letter dated 6/7/2023, my lord. I have bring it to the record.
Time of preparation.
ভুলকে deduction করেছে, they are proceeding.
Itu more, right?
Who is paying for NHDCL? You have made them party.
No, my lord.
Why?
Because my lord, we have to make the payment by the authority only.
You want how much?
11 lakhs.
11.
Only 11
Yeah,
lakhs.
that is admitted by the.
No, but the problem is, I may only direct them,
Yes, my lord.
but directing them won't help it. Because
No,
the
already
direction has to be also given to NHDS.
My lord, actually, what happened, my lord, the entire amount is deposited before the authority, my lord.
You have got the money?
Yes, my lord, this is here, my lord.
No, no, but if
There
you
is
see
a-
the last lines,
Yes, my lord, that
it may be mentioned and that in demand column 21 of the revised so and so was accordingly sanctioned by the energy. It appears the claim is genuine. Hence, proposal has been prepared for additional amount of rupees demand which will be placed to NHDF for sanction. So without the sanction which has
Yes.
not been given, how can they pay? Tell me. I can give you. You want that as they have admitted
Yes,
this,
it is
they will make a payment. So when? I can't direct them because IDCL is not a party.
My lord, actually, what happened during at the stage of the filing of this.
I
case-
can only direct them that after
Yes, my lord,
after getting the amount you disperse, you have got 23 lakhs.
no, my lord, I have got 78 lakhs.
No, understood. You have got 78 lakhs.
Yes, lakhs.
And there,
Uh,
while
out of
doing that,
7
they made a deduction of 55 lakhs.
Yeah.
They should have done the deduction of 40.
installment, my lord. They have made the payment by in two installment, my lord. First installment was another amount, second installment was another amount. When they have made the second installment, then 11 lakhs has to be paid, my lord. They have paid shortly 11 lakhs. Now my claim is that only 11 lakhs yet to be paid. There is now by this letter, it is admitted that the 11 lakhs is yet to be paid, my lord. My lord,
So you are limiting your prayer to 11 lakhs now.
at this stage.
Yes.
What is at this stage?
My lord, at the time of the filing of this case, my lord, no, not a single penny was paid to me, my lord. During the pendency of this case, my lord, and other,
So what is at this stage?
at this stage, my lord, only 11 lakhs yet to be paid.
So your entire claim now remains to only 11 lakhs.
Yes.
That's it.
Yes.
The instant writ petition was filed by the petitioner, claiming an amount, seeking a direction upon the respondents to disburse the amount of rupees 34 lakhs 12,785 towards the balance amount of acquisition compensation to the petitioner. Full stop. Pursuant to the filing of the instant writ petition, it reveals that notice was issued on 11/3/2020. This court duly had taken note of certain instructions which were placed on 11 on 4/1/2023. This court had taken into account certain instructions had taken into account that during the pendency of the writ petition, various amounts have been paid to the petitioner and the balance amount was rupees 11 lakhs only. And as such, there was a direction upon the State Council to obtain instructions regarding the reason for disbursement of the entire amount. Today, when the matter has been listed, Ms. M. Borman, the junior government advocate, have placed an instruction issued by the additional deputy commissioner, Kam Skala Viswanath, Kala all caps there. Wherein it has also been admitted that an amount of rupees 11 lakhs is to be paid to the petitioner, and for which proposal have also been submitted to NHIDCL for sanction. Taking into account that it is an admitted fact that an amount of rupees 11 lakhs is to be paid to the petitioner, this court therefore disposes of the instant writ petition with a direction to the respondents, and more particularly the respondent number
2 and 3, my lord.
respondent number 3. He's the competent.
Yes.
Respondent number 3 to take appropriate steps so that the petitioner receives the remaining amount of rupees 11 lakhs at the earliest. I can't fix a date, time.
3 months, my lord, if possible.
How? You have not made any NHIDCL. That is the reason why I'm telling you, na. At the earliest and not later than 4 months from the date of receipt of the certified copy of the instant order by the respondent number 3.
Obliged, your lord.
The instructions so placed by Ms. M. Borman, the junior government advocate, is kept on record and marked with the letterpress.
Obliged, your lord. Fine.
I'm praying for an accommodation, my lord, for another, in a week or two, my lord, I will have the instruction. Right now, it is not standing.
Ms. M. Borman appearing on behalf of the District Commissioner.
Yes, my lord, Deputy Commissioner Dhubri.
District Commissioner Dhubri submits that some time may be granted for obtaining the necessary instructions in terms with the order dated 14/8/2023. This is the matter again on how much?
2 weeks, my lord.
This is the matter again on 29th of September 2023.
Apply.
Learned counsel for the District Commissioner Dhubri shall ensure that the instructions are received without fail on the next date.
Obliged.
22.
What is this matter?
My lord, the construction work were nearby the military area, my lord. Kindly see page number 46 of my affidavit in opposition.
Construction of road. Page number?
Page number 46, my lord. The distance from the military boundary is 60 meters from the petitioner's boundary, my lord. As per my lord, 2011 notification, my lord. In clause 3, my lord.
Let us get to know what is the matter about.
Matter is, my lord, that petitioner started the construction work nearby the military boundary area within the 16-meter, my lord. In the Rongya, my lord, that is 60 meter from the boundary. Difference is 60 meter. As per 2011 notification, that should be 100 meter, but in 2016 that has been reviewed and that comes into 2010. And kindly see page number 44, my lord.
Now it is 60 meters.
Now it is, my lord, 2016 notification is under the process of review, my lord. So now that as per page number 44 of my instruction, page number 44, clause 2, my lord. In the clause 2, my lord. Construction activities in the city of military state till 2012 is governed by MOD guideline issued by letter dated so and so dated 18 May 2011. In 2016, these guidelines were reviewed by MOD to reduce the
reduce the construction activities from 100 meter to 10 meter, my lord, in 2016. Based on case taken up by the service, MOD is currently in process of reviewing its 2016 guideline. And in the interim period, UMC branch IHQ MOD Army has promulgated that LMA follow the MOD guideline of 2011, not the MOD guideline 2016. MOD guideline 2011 is, my lord, 100 meters. And MOD guideline 2016 is the 10 meter, my lord. As an interim measure that promulgated to follow the MOD guideline 2011, my lord. So, my lord, that is under the review 2016 guideline, my lord. But the construction work is going on within the 16 meter from the boundary area of military, my lord. As per this, notice has been issued to the subdivision Rongia by the military service, case number 46, my lord. That is the case, my lord.
Show me the impugn orders.
Impugn order is, my lord. Impugn order is, my lord, 9/1/2020, page number. Page number 14, my lord, of the writ petition.
14.
14, my lord. Notice for stopping the construction of house, my lord. That is from subdivisional officer Rongia, my lord.
We do one thing. As the petitioner is not present,
Yes, ma'am.
we will have it on some other day.
Yes,
If he is not appearing, then we have to dismiss.
yes, ma'am.
Now, is there any interim order?
No, ma'am.
Now, his construction is within the 60 meters.
Within the 60 meters.
None appears on behalf of the petitioner on call. Under such circumstances, this court fixes this matter again on 25th of September 2023. It is made clear that if the petitioner is not represented on the said date, the instant petition shall be assumed that the petitioner is no longer interested in the instant petition, and accordingly consequential orders shall be passed.
23.
Yes,
Lord,
Mr. Sen.
the present, this petition is filed, my lord, against the, my lord, some serious discrepancy, my lord, committed by the society. My lord, respondent number 4, 5, 6, and 7.
What have this Arya Smart Living Group
My lord,
Housing Society done to you?
my lord, your lordship kindly see, my lord, annexion number 6,
Huh?
my lord, annexure 6,
Annexure?
6.
Yes. Who are you?
I am the member of the society. Sir.
You are a member of that society.
My lord.
Now, what is your
My
problem?
lord, my basic grievance is, my lord, there are some other irregularities, but some of them has been sorted out. Now, my lord, the basic grievance of the petitioner is, my lord, the registration of the society, your lordship will find at page 64, annexure 6.
Page?
Page 64, my lord. Annexure 6.
Hmm.
It is the, my lord, registration certificate. Has your lordship got it, my lord?
Annexure 4.
Annexure 6, my lord, page 64.
Okay, got it. Yes.
My lordship, kindly see the date of, my lord, the certificate.
10/6/2019.
10/6/2019, my lord. Your lordship is correct. Now, my lord, your lordship kindly come to page, my lord, 57, annexure 5. My lord, this is an agreement. Lordship, kindly see the date of agreement, 8th day of April 2019.
Then
My lord, this agreement has been made in between the respondent number 5 and the, my lord, promoter builder respondent number 3. My lord, prior to incorporation of the society, your lordship has found the society has been incorporated on 10/6/2019. And this agreement was made, my lord, on 8 April 2019, prior to incorporation of the, my lord, the society. My lord, which is violation of section 10(2) of the Cooperative Society Act 2007.
what does it say?
Yes,
Cooperative.
your lordship, kindly see, my lord, section 10, subclause 2 of the Cooperative Societies Act.
Yes. What is wrong with it?
My lord, lordship has got it, my lord, section 10. My lord, provided portion, your lordship, my lord, kindly see, my lord.
Yes.
Provided that, my lord, has your lordship got it, my lord. My lord, may I read, my lord? Provided that no order of refusal shall be made without an opportunity of being heard to the applicant, the certificate of registration signed and sealed by the registrar shall be conclusive evidence that the society mentioned therein is a society duly registered under the Act, unless it is proved that the registration of the society has been subsequently. No cooperative society, this is very important, sir. No cooperative society shall commence business unless it has obtained a certificate of registration under section 11 of the, and after being prior license permission if necessary under the state or central. And in such business or every such business of the cooperative.
So, Mr. Sen, what is your problem?
My lord, by this agreement, my lord, now.
How are you aggrieved?
My lord, by this agreement, they are now, my lord, producing this, my lord, agreement in various forums. There are so many litigations against the promoter, my lord. Now he is using this particular agreement, my lord, in his defense against us.
Against you means how?
My lord, your lordship, kindly see the terms of the agreement, my lord. The terms of the agreement, the contents of the agreement, my lord, absolutely unitarily, my lord.
Huh?
Arbitrary.
Arbitrary?
Yes, my lord. That the clauses, my lord, that has been given in the agreement, my lord.
Who is using it?
My lord, this respondent number 3, that is the promoter, builder, against whom, my lord, so many cases, litigations are pending before.
No, who is doing it?
My lord,
Who is doing it? Arya Erector India Private Limited or Arya Smart Living Group Housing Cooperative Society Limited?
society in between members of the society and the builder.
So it
My
is
lord,
a dispute between you
yes,
as well as with the society. Why should this court interfere?
my lord, because prima facie, my lord, the society cannot.
What does it say? You can't start your business. Does it say that you can't enter into an agreement?
Agreement also is a kind of.
Nothing doing.
Transaction business, my lord.
Don't have a case.
Because, my lord, by that agreement, my lord, we are agreed, my lord. They are using my lord, now using this, my lord, this agreement as a tool of their defense in different cases, my lord, in different forums. That's why, my lord, your lordship may be pleased to, my lord, my lord, pass appropriate orders to the register, my lord, to look into this agreement, my lord. We have filed representation before the register, but register did not act upon it, my lord.
Yes, Corporation Department, what do you have to say?
Lordship, may kindly have a look their prayer approach, my lord. They have under the page 11, my lord. Another fact and circumstances most respectfully prayed that your lordship, honor will be pleased to admit this petition called for record, the issue is so. And as to why written on nature manner cannot be issued directly response number 1 and to take necessary action against the Arya Smart Living Society. This is their prayer, my lord. Only take action. Lordship, may kindly have a look paragraph 15 for a moment. Page 9.
Yes.
May I read, my lord? That it is pertinent to hear that the president of the Arya Smart Living Group Housing Cooperative Society Limited, situated so and so, per his letter dated so and so requested the Register of Cooperative Society Guwahati for cancellation of the agreement of so and so as the promoter body member do not accept the state agreement. Regarding that, lordship, I have received instruction from the registrar, lordship. Lordship, may kindly have a look at the relevant person.
No, this is okay.
My lord.
I've seen it, but that I have also thought about it. But the question is,
Lordship.
what have you done to his application? He has submitted a representation before the Register of Cooperative Society. What have you done with that?
Page 72 or 71, my lord. 71, the type copy, my lord. It is issued by the ARCS Bangagar to the President Secretary of the Arya Smart Living Group Housing Cooperative. Whether they have complied his advice or direction that the petitioner constantly appraise this honorable court.
So you have done this.
My lord.
So what remains? Nothing.
No, my lord, they have not done it, my lord. They have simply, my lord, make an inquiry thereafter.
Mr. Sen, there is nothing out there, all these things.
My
These
lord,
things are absolutely, go to the civil court, do this, whatever you want, go there. You can't resort to this
my lord,
226
your lordship
jurisdiction.
kindly appreciate, my lord.
No.
We have filed representation before the authority, but
First,
authority
who are
did
you?
not- my lord, did not take.
No,
note of
first,
it.
who are you?
I am, my lord, member of the society.
How do you show so? Show me how you are a member.
Lord, yes, my lord, your lordship kindly see, my lord, I have documents, my lord. Voter list, my lord, and this order of the register, my lord. Earlier, my lord, this thing was rejected. Thereafter, my lord, I filed appeal before the register.
How are you affected with that agreement?
My lord, we are affected with the.
We are named, there is only one.
Yes, only one. my
You
lord.
are affected, how?
My lord, by this agreement, my lord.
Hmm.
Number one, my lord, it is in violation of, my lord, section 10(2). Number two,
That is not in violation of 10(2).
my lord, it is, my lord.
No,
Your lordship can be appreciate, my lord,
no.
that the smart living company, my lord, the society, he cannot enter into any business. Business means in the sense, my lord, any transaction.
So there is
or
a direction to include you as a member of the society.
My lord, thereafter.
You are not still the member of the
No, I
society.
have been included, my lord.
There's nothing
my
on
name
record.
appears in the voter list, my lord, my lord, my lord, that is there, my lord, with them. Now I have become, my lord, member of the society.
I am appearing
You
for
are-
the promoter, my lord. First and foremost, the society is not a party in the record.
Huh?
He is seeking a relief against the society. Society is not even a party. I am appearing for the promoter, my lord.
My
You
lord,
entered into an agreement with
Yes.
the society for what?
My lord, for handing over the managing of the common areas. That agreement is not under challenge before any civil court.
no, my lord, your
If they are aggrieved by the agreement, my lord, they should challenge it before the appropriate forum of law, my lord.
my lord, your
Lordship has seen that they filed a representation, registrar has carried out an inspection, issued some directions, but they are not happy with that. They have to challenge that, my lord.
When
Page
was
7,
this agreement entered into?
8/4/2019, my lord.
And he was not a member of the
He
society.
was not a member. He came into the picture, my lord. He came into possession of his villa in November 2019, my lord.
My lord, the.
Well, if they are
inaugural-
rejecting it, my lord, let them take a resolution in the society.
My lord, in the inaugural meeting, my lord, I was not invited, my lord.
He was not even a allottee at that point in time, my lord.
And how are you aggrieved with this thing? I don't understand. How can you be aggrieved when the society has been given, where you are a member, the society has been given a particular thing for using the common facilities? How can you be aggrieved?
Not only common facilities, my lord.
What
Your
else?
Lordship kindly see the contents of the agreement. my lord.
Yes.
My lord, Lordship kindly see.
How are you aggrieved?
My lord, it is agreed. Lordship kindly see, my lord, the contents of the agreement.
Yes.
My lord, at page 62.
Page?
62, my lord.
Now, what is this? Page 57?
57 is my lord type copy. I am, my lord, I have also annexed, my lord, the agreement itself, my lord, the.
Yes,
my lord,
yes. Where is it?
Page 62. Page 62, my lord. And whereas, as your lordship got it, my lord,
It
and
is agreed that the registered
agreed
office of
that the
so
registered
shall be exempted
shall
from
be
payment of
exempted
my
from all charges. How is this, my lord? Why they will be exempted from all charges, my lord? Number two, my lord.
This is absolutely a civil dispute. Why should this court? And number two is what?
My lord, but my lord,
Can
register
avail
should take a
affidavit.
call, my lord, on this dispute, my lord. We have filed representation before the register, my lord. Register
The
did not
instant
take
writ
a call.
petition has been filed. You argue all these things before division bench. The instant writ
Your
petition has
lordship
been
kindly
filed,
appreciate, my lord. Where
seeking
shall I
a
go, my lord?
direction,
Lordship,
seeking a direction.
lordship, give me a liberty, then I shall agitate before
What?
the civil court.
You want to withdraw? Liberty is already there.
My lord,
Should I give you a liberty? Are you withdraw? I can give you a liberty.
lordship,
But this court is not going to interfere with all these things. You have any problem out there? Yeah, because the moment I pass an order, I will say everything is okay. What do you want?
But your lordship kindly appreciate, my lord. If it
Mr.
is a
Sen, kindly
disputed-
come to the point.
My lord, if it is a disputed question of fact.
There is no the question of dispute. You have no right. Simple question under 226. You want to avail remedies in the civil court, do it.
My lord,
But this has nothing to do.
that observation, my kind.
What do you want?
My lord,
You want to withdraw with liberty?
with liberty to file.
That is better. Mr. The learned counsel appearing on behalf of the petitioner submits that taking into account that the matter in issue, the dispute in issue, primarily lies within the jurisdiction of the competent civil court. And or appropriate forums, but not for invocation of the extraordinary jurisdiction under Article 2 to 6 of the Constitution. The petitioner may be permitted to withdraw the instant writ petition with the liberty to approach the appropriate forum or the competent civil court. Taking into account the above, the instant writ petition stands closed on withdrawal. However, it is made clear that the withdrawal of the instant writ petition shall not prejudice the petitioner to approach the appropriate forum and or the competent civil court if so permissible under the provisions of law.
I am obliged, my lord. Obliged.
Take this, you may require it.
I am obliged.
24.
Yes, Mr. Bora.
My lord, the matter pertains to cancellation of the PDS, the details of license of the petitioner, my lord.
PDS license.
Yes, my lord. Annexure 15, page 47. The government was supposed to file affidavit, my lord.
My lord, although last occasion it was stated that
The violation of the clause of defense. Licensing. Madam, don't you think you have to give reasons?
Yes, my lord. But in
Yeah.
parawise reply also no statement reasoning. is there.
Understood. There is no reasons in the order. We set aside this order. What is this type of order?
Yes, my lord.
And his reply to the so-called notice was received on so and so, which is not satisfactory. My goodness. Civil consequences. You have to give basic reasons.
Yes, my lord.
Huh?
In parawise reply also it is not reflected, my lord. So this
Sorry, the
affidavit
case
would
was-
not.
Now, would you like today that this court said this order is set aside? Would you like it? No. You also want,
Some
there has
reasoning,
to be some reason given. Civil consequences. We set aside this, giving you the liberty. And the proceedings shall go to that stage of prayer and within
Issuance of
90
notice.
days, na?
Yes, my lord.
Within 90 days, you have to complete the entire thing and do whatever you like.
my lord.
Consider his so-called reply, which was submitted on 24 to 2018,
My lord.
and then do it within a particular 90 days. How much time is there within?
Within 90 days. My lord, the proposed reply also there was some issue, my lord. So I may be given liberty to submit a fresh proposed reply. Because the petitioner is a illiterate person. If your lordship peruses the proposed reply, they drafted one proposed reply and asked the petitioner to put his signature. So from that stage, I pray that, my lord, the petitioner will file a proposed reply to the proposed notice. From that stage, my lord, it may start it, my lord. Because, my lord, initially the case was simple, my lord. The petitioner was running a shop. Two person came to the petitioner, official, government official came to the shop of the petitioner stating that someone has filed an RTI application seeking some information regarding the shop of the petitioner. So they demanded some money from the petitioner. The petitioner could not pay. The petitioner filed a complaint case against those officials also, my lord. That complaint case also I have annexed here with my lord in the writ petition. Subsequently, the officials assured petitioner that you withdraw the case and we'll give you the, we'll allow you to run the shop, my lord. He withdrew the case, my lord. Thereafter, they have first suspended his license, then cancelled it, my lord. Because the petitioner,
These are things which this court can look
they
into.
cannot look into.
I am only
My-
touching on the that order.
My humble,
Order, you are running a shop out there. He has certain rights out there.
Yes, my lord.
And it can be suspended or done away with only by way of some order which has some reasons. Take on the auction, some public distribution order. Where is that?
yes, my lord, I have a copy of that.
The instant petition has been filed challenging the order dated 27/3/2018 issued by the Deputy Commissioner Hosai Sankardev Nagar, whereby the petitioner's license bearing number HJS/EDS/F.P.427/86 was cancelled with immediate effect. A perusal of the instant writ petition shows that on alleged violation of certain clauses of the Assam Public Distribution of Articles Order 1982 and the terms and conditions of the license, the license of the petitioner bearing number, hey, I got number 2, was suspended under the provisions of clause 15(1) of the order of 1982, and the petitioner was asked to submit his show cause by the communication dated 12/2/2018. The petitioner duly submitted his show cause reply, which was received by the office of the Deputy Commissioner Hosai Sankardev Nagar on 24/2/2018. However, most surprisingly, the Deputy Commissioner Hosai Sankardev Nagar rejected, cancelled the license of the petitioner merely by stating that the reply file submitted by the petitioner was not satisfactory. No other reasons was assigned as to why the reply was unsatisfactory. Full stop. This court, it is a well-settled principles of law that when an authority exercises jurisdiction, when an administrative authority exercises a jurisdiction and there is no reasons assigned therein, the said order so passed without assigning any reasons renders the order arbitrary and unreasonable, and thereby violates the mandate of Article 14 of the Constitution. Taking into account that there was no reasons assigned in the impugned order dated 27/3/2018, the said order is in violation of Article 14 of the Constitution, and accordingly, the same is set aside and quashed. In that view of the matter, in view of the setting aside of the order dated 27/3/2018, the matter stands restored back to the date, restored back to 12/2/2018, when the petitioner was issued the show cause notice and his what is this? His license was suspended. Mr. D.P. Bora, the learned counsel appearing on behalf of the petitioners, further submits that there are certain additional materials which has come into light which he would like to place it before the Deputy Commissioner Hojai Sankardev Nagar. Taking into account the above, this court permits the petitioner to file an additional show cause reply, thereby enclosing such other documents as deemed proper for the purpose which has relevance to the show cause notice dated 12/2/2018. This court further directs that taking into account the mandate of Rule 15, Section Clause 15,
My lord, I have tag marked it, my lord.
Clause 15,
15(1) and
15(2) of the Order of 1982, the Deputy Commissioner Hojai Sankardev Nagar, or now, do you have a Deputy Commissioner there?
now it has marked it no now.
ADC Prabhatin.
Huh?
Oh, ADC Prabhatin.
Or the ADC in charge, Hojai? Now again, Hojai has become a district.
Yes, my lord. So far as my knowledge, that merger is already been, it's no longer in practice, my lord, because after this delimitation, my lord, notification, all those
Now you have a district Deputy Commissioner.
perhaps, my lord, but that's appropriate notification I have yet not gone to.
Whom should we direct?
Lordship may direct DC oblique ADC, my lord.
Or,
Both
or
the
the ADC in
whoever
charge,
is in
Hojai,
charge, my lord.
to decide the said proceedings initiated on the basis of the show cause notice dated
12/2/2018.
12/2/2018 within a period of 90 days from the date on which the petitioner submits his additional reply to the said show cause as directed herein above. Full stop. Consequently, the instant petition therefore stands allowed with the following directions and observations. The order dated 27/3/2018, passed by the Deputy Commissioner Hosai Sankardev Nagar, thereby cancelling the license of the petitioner bearing number so and so, is set aside and quashed. Number 2, the position is set aside and quashed, thereby restoring the position to the date 2/12/2018 on the date on which the show cause notice was issued and the petitioner's license was suspended. The petitioner is given the further liberty to file an additional show cause reply within 10 days from the date of the instant order. So it is made clear that if the said show cause reply is not submitted, additional show cause reply is not submitted within the period mentioned, the Deputy Commissioner Hosai / the additional Deputy Commissioner Hosai shall bring the said show cause bring to a logical conclusion the proceedings initiated on the basis of the show cause notice dated 12/2/2018 on the basis of the available materials. Next. It is further directed that in case the petitioner submits the additional show cause reply within the time above stipulated, within 90 days therefrom, the said show cause reply, the said proceedings initiated on the basis of the show cause notice dated so and so shall be brought to a logical conclusion. With the above, the instant petition status.
Obliged.
Deeply obliged.
25.
What remains in this matter?
In relation to lawsuit order, the hotel is still running online.
Hotel is running?
Yes, ma'am.
How?
My lord, they have submitted a affidavit of opposition. Kindly, it is start from 179.
Huh? Who is appearing for GMDA?
Respondent number 7. Let's file an affidavit of opposition.
Who is respondent number 7?
I appear for the promoter,
Huh?
builder. I'm appearing for the builder. I'm appearing for the builder.
Yes. You are running?
No, C is not under my, is not under my possession anymore.
Who?
It is there were 3 buildings that are concerned in this petition, your lordships. A and B and C. A and B initially I was supposed to construct all the 3 of them, but I could not construct at a later stage. Subsequently, C has been handed over to the owner. That is where I think my senior counsel, Mr. Didas, is appearing for the gentleman who's in possession of that building and running that guest house come.
He gave an undertaking that he
yes,
would
I
not.
think he'll be.
Your lordship, I'm appearing for 7.
Yes.
And it does is leading this case. Your lordship, what has happened is that we have complied your lordship's order. There is no violation as such. However, your lordship has given the liberty that we can do as per law. Accordingly, we had applied to the GMC because in residency also we can run guest house, not hotels, your lordship. So we have applied for guest house permission, which we have got. And after all due permission, all the statutory approvals, we are running on our guest house as per the approval of the GMC, which is we have given in our affidavit in opposition.
Where is it?
But your lordship, that we have filed on 8/9, I think it is not on record, your lordship. So I pray that your lordship may take it either tomorrow or after, then Mr. Tidas would be able to apprise your lordship.
Mr. Counsel, and this court is not bothered who appears or not.
Yes, sir.
We are concerned about the matter.
Yes.
Huh? Or should I go? Should this court go there where Mr. Das is there sitting? Then
So we have filed
Don't
an
make all
affidavit
this
to bring
submission.
on record all the approvals.
I hereby undertake before this honorable court that I will use the building only for residential purpose, and if I let out the so and so to any other person in the future, I will not let out the same building for any purpose, any kind of commercial until the GMDA allows to use for commercial purpose. So now the GMDA has permitted it.
Yes, only for limit 16-bed guest house.
So there, where is that? That affidavit has not
That I
come.
have filed on 8/9, your lord.
And you have not challenged that.
My lord,
He is not challenging.
Kindly see the IA number 3747, that there is the your lordship order is there.
That is my IA, Your Lordship.
This is there, just for the order. Kindly see page 37.
You are the owner.
No, I am the builder. I had an agreement with the owner to build the three.
Okay.
buildings.
That's for your lordship order. Page
Admit
34.
and direct the adjourn to consider
Para-
regularization of A and B in respect of Nirupama Niwas so and so in accordance with law.
So,
Now, has the GMDA done it?
yes, Your Lordship. May I just point out this, Your Lordship? So on 18th of 11 of 2022, I have annexed it at my IA. Your Lordships has passed certain directions.
Hmm.
According to me, an extremely equitable order was passed in which one direction that has been given at page 34. That's a 6 directions passed by Your Lordships only.
Hmm.
In it says, order says the order passed herein above shall not affect the power and rights of GMD and GMC to take appropriate action in the respect of any other transgressions in the following provisions of law.
Yes, sir.
GMD and GMC are further given the liberty to proceed in proceedings already initiated against respondent number 7 and 10.
Yeah.
So in terms of this Your Lordship's direction, there was a show cause notice issued. I have in fact written 2 letters which I have already annexed in my IA and said that whatever is permissible under law, please given the provision, I'm ready to comply with whatever is required to be done in regards to my violation, which is as a builder. Now, A and B are residents. There are 23 flats already sold, 9 flats belongs to the owner. Now, in regards to that, the violations that they are talking about will have to be reassessed by GMDA because my initial occupancy certificates now stands cancelled. The word used in the cancellation is irregularity. So my prayer before in this IA was that since Your Lordships has already passed a very equitable order, GMD and GMC are in possession of this property. They can look into the affair. Whatever is required, I'm ready to comply. So that's all my request was. That's why I filed the IA to say that let the authorities take an appropriate action. I'm ready to comply whatever comes. Whatever the violations, either qua me or by the person who's running the commercial establishment.
Now, have they regularized?
There's only
Or are they saying that the matter is pending, so not
They
to
have-
regularize?
they have not come forward and taken a decision yet. That would be my
That's a
respectful
different
submission.
thing, but the thing is, this court has given the liberty to the GMC, GMDA.
Yes.
So under such circumstances, why do you need an order from this court? This court has given everything to GMC,
Absolutely. I
GMDA. Where is the
vote for
GMC,
it.
GMDA? GMC, GMDA is not appearing. They seem to be not interested.
According to me, with all due respect, there's nothing survives in the petition because everything has already been taken care by an extremely equitable order by Your Lordships. So it is for the authorities and I'm ready to comply.
GMC, GMDA is not there, so we will ask the CEO who was there, the GMDA. He has earlier been appeared. We should ask him to be personally again present. Let's see what they have done.
May I please, Your Lordship?
Yes.
I am appearing on behalf of P. Nayak, Your Lordship.
Has he given a wakalat number to you?
No, Your
Then-
Lord-
You appear for a counsel. Is this the state of affairs? You appear for a client, I suppose, not a counsel. Tell me. What do you have to say?
I thought on the records, Your Lordship, so kindly pass over the matter for time being, Your Lordship. He will apprise the court.
There was also a direction and that I should file a reply. I couldn't comply to that. My reply is ready, but I couldn't file.
No, this court has given all liberty to the GMC and the GMDA. They have to do it. Why should this court further direct for consideration? Tell me. Or is it that you have filed, you have asked for regularization and not they are not doing it?
They have,
Wouldn't that be a separate cause of action
if
for a
not-
writ petition?
they have given an order passed on a certain representation, but they have still not given any final orders to be passed as what needs to be done
Understood,
for-
but the relief which you are seeking out here in the IA,
Yes, sir.
wouldn't that come within the ambit of a separate cause of action specific for you? You are a respondent in a proceedings. How can you ask for this relief?
The reason is because both the authorities have now spoken as the entire 3 buildings to be as one possession, which was initially with me. The violation qua both A and B, which is a residential, and C, which is now being termed as a commercial, falls under my responsibility initially. I would suggest that if any violation happens, Kwame will have to be taken care by GMD as well as by GMC. So I am only making an endeavor that let the agency independently decide this. That's all I'm saying. Because your lordship says
But
already.
why will this court pass an order in your eye?
All I was requesting is your lordship, in that case, the writ petition can be closed and the GMD and GMC can take an appropriate authority and can take a decision.
This will be closed only if we take into account that the GMDA has given him the permission of a
Yes, that
16-bedded thing.
Yes.
That is one aspect of the matter. But as regards the other violations which he is alleging out
Yes,
there,
sir.
I have given the GMC and the GMDA to take action.
Yes.
Whether they have, if they have not taken any action pursuant thereto, which the petitioner still continues to be aggrieved. And how can this court then close this petition on the basis thereof?
In that case, your lordship, I would say that I have to comply with your last order of your lordship to file a reply because there are certain violations after that also.
That is a different aspect of the
So then
matter.
your lordship can hear me on
The
that.
various violations, they are pointing it out on the ground that the inaction of the GMC and the GMDA, for that they have come before this court. That is another aspect of the matter. But what you are asking in this IA falls outside the scope of the writ petition for you to get. You are a respondent.
Yes.
How can you ask for this relief? That this court should direct the GMC and the GMDA
Only
to
in terms of
consider
your
your
lordship's
case for it,
directions.
because it will depend on that you have submitted, or it presupposes that you have submitted an application for reconsideration.
Yes.
That reconsideration application is not being taken note of.
That is only in terms of your lordship's directions.
No. That is,
I'm only saying in terms of your lordship's directions.
I never said that for you to submit an application for regularization. Did I say?
The directions initially given your lordships.
I never said so.
No, in fact, the violation that have the directions that were passed, your lordships were passed for the violation that respondent number 7 had conducted.
No, where I have
Page
directed,
33, your lordships.
I have never directed.
No. All I'm saying, your lordships, is my application was for these directions to say that if I may.
So, Mr. Puppan, the question is, when this court have not directed anything, you sought for regularization. Go for regularization. This court even said, whatever you want to do, do. Let the GMC and GMDA take a call on that. That is absolutely clear. But if it is not being done, wouldn't that be a separate cause of action for
In that
this?
case, I think
Maybe
your
at
lordships-
best, this court can take that writ petition with this writ petition, which is a different aspect of the matter. But can you say that it arises out of this writ petition, being a respondent, you are entitled to this?
I'll consider that, your lordships. I'll consider that. But the fact still remains is that the violation qua, which has been pointed out in the last order, qua in 1811, was in directions qua violation that was happening qua me. The respondent number 7's violation is only qua the fact that they were running a commercial establishments. Whatever directions fell through that. Now I am before your lordships only to say that let C and B, which are already residential complexes, should be regularized and only in terms of what is permissible in law, and I'll do whatever is required to be done.
Understood.
That's
So
all I'm
why
saying. your
should
lordship.
this court give you or pass a direction in an IA which is outside the scope of the writ petition? You have a grievance against the GMDA or GMC and not doing it. Not regularizing. Because this court never said that to GMC or GMDA to regularize.
I agree. All
This court only allowed the GMC and GMDA. They were only apprehensive on the last occasion when the matter came up. They were apprehensive that in view of the pendency of the writ petition, they were not doing anything. That is the reason why this court made this very clear, the direction to the effect that whatever directions have been made shall not affect the adjudication by the GMC and GMDA if they wish so. That is the basic reason why it has been done. So now, if you have filed an application seeking regularization, very well, they should do it. If they are not doing it, then it will be a separate cause of action as to whether it will come within the compoundable elements or not.
if
But
that much-
don't use this court as a post box.
if your lordships can clarify to that extent. I'll
Why
be
should I
happy.
clarify?
I'll be happy.
So we'll close this eye, giving you liberty to file,
Grateful.
approach the authorities, whatever
be
you
extremely
feel
grateful.
like. Because that is a separate cause of action for which a separate,
Grateful.
that's all. And in regard the other one, madam, have you given that there? Yes, madam.
Your Lordship, he is on the legs, Your Lordship. So I pray for some time, Your Lordship. Kindly pass over the matter for time being, Your Lordship.
No, it's okay. You see, I will give it some time because here they have filed some affidavit.
Mm.
You have been given a copy of that,
Yes, to GMD we have given.
not GMD.
GMD also we have served copy. We have served copy and also to the petition.
GMD is not a party.
Yeah, we have given,
Then why you have not given it to GMD?
we have given copy before file. If need be, I will file extra copy, but I have given copy.
You see, what has happened is this court, specifically, there was a permission which was granted was only for residential building. Now, thereupon, what has happened? They started a hotel, which is commercial. There were certain directions passed by this court. The CEO, Mr. Hilali, was present. I gave him the liberty, whatever you like, and I directed them to immediately close down the building, close down the
commercial.
hotel.
Commercial.
So the hotel was closed, it was sealed. Then they came up with an application. I think at that time just Mr. Sahewala was appeared. Came out with an application that there is some marriage to that effect, so kindly don't seal it so that we may use those rooms only for the purpose of accommodation. We shall not do any business of any commercial. Right. So I granted them and also made it clear that they shall not do unless they get the permission from GMC or GMD. Now thereupon they get a permission from GMC or GMD to that effect for running a 16-bedded guest house. So this is the state of affairs. And that affidavit is not on record. So that is the state of main conduct. Mr. Asham appearing on behalf of the respondent number 7 submits that an affidavit in opposition, an additional affidavit.
He has filed an additional affidavit, so it's an affidavit.
Who has filed
The
this?
petitioner.
No.
I filed an affidavit.
Forget about them. I'm asking you, what did you file?
Petition against the additional affidavit filed by petitioner.
I filed an affidavit in opposition against the additional affidavit filed by the petitioner on 8/9/2023. However, the said additional affidavit is not, said affidavit is in opposition is not on records. List the matter again on
Instruction to enable it.
27th of September 2023. The instant interlocutory application has been filed by the respondent number 10, seeking a direction from this court upon the GMC and the GMD for consideration of the application for regularization, for consideration of for a direction upon the Guwahati Metropolitan Development Authority to consider the regularization of Block A and Block B in respect of Nirupama Niwas building at Village Jotia, Kahilipara Road, Guwahati, in accordance with law. The said application. From the said, from the documents on record and a perusal of the instant petition, it transpired that the respondent number 10 being the respondent number 10 being a respondent in the instant proceedings cannot maintain the instant application seeking the directions against the GMDA. More so when the said directions are substantive in nature. The cause of action as to whether the cause of action as to whether the GMDA have rightly or wrongly not considered the case of regularization of Block A and Block B in respect of Nirupama Niwas building is a separate and a distinct cause of action from the writ petition, from the accompanying writ petition. Under such circumstances, this court is not inclined to entertain the instant application. Be that as it may, the petitioner would be at liberty to file a writ petition if so aggrieved with the inaction on the part of the respondent GMDA for not regularizing the Block A and Block B in respect of Nirupama Niwas building, if so aggrieved.
Great.
So advised.
Your lordship said
I see.
petition, I am the applicant in this. Your lordship said petitioner, I am the applicant in this.
Respond number 10.
Yes, I am the applicant.
I will respond number 10. Public applicant. Go ahead.
Grateful.
Lordship,
Yes, Mr. Naik.
One document I would like to place, Lordship, on 24th of March 2023, Lordship. One letter was responded to Mr. Suresh Kesriwal, Lordship. He is the builder, Lordship. And there, Lordship, the occupancy proposal furnished from your end is not considered by this authority and hence rejected. And that is the reason for not regularizing. Lordship.
No, let him do it, whatever, because how can, isn't this a separate cause of action?
Lordship, I'm only in respect of that word non-action, Lordship, inaction.
That is what the lordship has submitted.
No, that is his claim.
Lordship.
If he is aggrieved by inaction, very well.
I'm saying I can go and file a separate.
I'm not touching on the merit
Merit.
on this application, because why I'm not touching, because he being the respondent number 10, he cannot maintain an IA in his writ petition
Yes,
for the purpose of getting that is a substantive relief for a direction for regularization.
Yes.
So for that, giving him the liberty to file a writ petition, this court. Now the second issue is, they say that this court granted the permission to the GMC and the GMD to take recourse to what other provisions of law for doing whatever is necessary. This court never said anything to that effect. Now, this court further directed that unless this commercial is not changed by the GMC or the GMDA, they cannot do any business out there. Now, what has been informed by Mr. R. Sharma, appearing for the respondent number 7, that in the meantime, they have got the permission from you for constructing, for having a 16-bedded guest house. Just find out.
That I have to confirm.
Yes, that is why I'm fixing it on
29.
Lordship, one more aspect is there, Lordship, on last day, Lordship.
because now they again running.
One
On
undertaking was
on the
given.
basis of your permission. That is what is happening.
Okay. Permission, yeah.
No, because it's a mixed use, because in residence.
In that
we
case,
get-
not
So
required.
that is why that affidavit I have asked them to bring it on record. Once we take it up, you get your instructions on that.
Lord,
Grateful.
obligement.
I এখনো একটা line লিখে দিব। This court further finds it relevant to take note of that the submission made by Mr. P. Naik, the learned counsel for the GMDA, who submits that the pursuant to the application filed by the respondent number 10 applicant, by an order dated 24/3/2023, 24/3/2023, the Chief Executive Officer
Yes. Lord. Chief Executive Officer.
of the GMDA had rejected the said proposal. And as such, and as such, there has been no inaction on the part of the GMDA.
Obliged.
27.
May please, Lord.
Yes, Mr. Sharma.
My lord, the matter relates to non-handling of the possession of my lord, land which has been settled with the petitioner. Handing over of the possession of the land which has been settled with the petitioner, my lord.
Oh,
Lordship will find the page 16 is the my lord order by which my lord land measuring 1 quota 10 lessa has been settled with the petitioner, my lord.
And it is third paragraph, Lordship will find the possession of the land may be handed over and the land records be got corrected on receipt of the due premium from the petitioner in full. Subsequently, my lord, that order has been modified and the premium amount.
Yes, Mr. Talukdar, what have paragraph 4 and 5 of your affidavit?
My lord.
You admit that a settlement has been made in favor of the petitioner?
There's one affidavit has been filed by Sikavasam. But it says that it is silent about the main issue.
Main issue means?
Whether that premium was deposited or.
No.
I have an
Everything has been settled out here. You see, kindly see paragraph 4 and 5.
Yes, man, from his iteration. it
During
appears-
civil inquiry, it is found that the petitioner has no possession in any portion of the land covered by the aforesaid new dark number which is created in so and so. Prior to that, it is seen available Chita records in so and so.
Which
And the
shows
old
that
dark
the land-
number mentioned in paragraph number and no portion of the land has been included in the period of so and so in the name of the.
petition.
Let's see your settlement, Mr. Sharma.
My lord, Lordship will find the page 16 is the, my lord,
Page
16, my lord.
16. Here, reference to the one I'm. To appear for settlement on. Now, have you paid the amount?
Yes, my lord. I have annexed, my lord, that the
The challan, sir.
challan, page 20, my lord.
The challan has been given.
My lord, page 20, my lord.
Now, what have they acknowledged it? Have you submitted this challan to these people?
My lord, this is the head of account is there, my lord, in the,
No, understood. You paid in 3 installments.
yes, my lord.
See,
You were supposed to pay this amount of 15,000 when?
Yes, but my lord, I am the, my lord, Lordship will find that has been modified, my lord, page 18. 18, my lord. Second paragraph.
Belongs to you will get 25% exemption on payment. So that amount has been reduced.
Yes, that amount, the total amount comes to my lord, yeah, after 20%, 25%, my lord, 16,875. And my lord, I have paid 5625 into 3.
Okay, then
My lord, I have submitted subsequently representations, my lord, that has not. My lord,
this happened in 1993. Then what are you doing all
my
this
lord, I
while?
have submitted several representations.
No, understood. But what were you doing all this while? Giving representations, I understood. But what happened? Why were you all along sleeping?
I am not sleeping, my lord, I have approached before the authority, my lord, they have not done anything. That's why, my lord, I have approached before.
The near name till now has not been included in the chita. Obviously, you were sleeping all along. So that land of 687 is exhausted?
No, my lord, that has been, my lord, renumbered, my lord, as per affidavit, my lord.
No, that I have seen it. So during the resettlement operation, it has been renumbered, but is it exhausted now?
That we might have been, I do not know, because it has been shown as government cost after that, after the new.
Where? It is not shown anywhere.
No, it says in the paragraph 5, Lordship.
Huh?
Mentioned in paragraph 4, affidavit of portion and no portion of the land has been included in periodic patta records of the said village and Moja in the name of the petitioner.
In the name of the petition.
No, then my lord, paragraph 4 it says somewhere.
No, that is why.
And
sir,
still in the available Sita
no,
records.
Mr. Talukdar, therefore I'm saying, you see the entire land of 687 dal
That has
been
been
bifurcated.
So many darks.
into various dals.
Mine.
Now, this still continues to be government land.
It says that, as it says, man.
Now, Mr. Sharma, have you seen it where your land falls?
My lord, that particular, my lord, exactly location, my lord, I could not find that.
Mr. Sharma, you need to advise your client properly. You see, what is to be done in this case? Are you in possession of any land?
No, my-
You were never given, you were never in possession.
I'm never in.
So you don't know where you are.
Locations of the land, my lord, I don't.
You know. You don't know.
My lord, the village, my lord, and the area I know, but the particulars that the land, the one quota 10 less as that, my lord, I don't.
So you were never given a possession in 1993.
No. And these in the settlement order, the direction was there to give my lord possession. My lord. It was there, my lord, in the settlement
So
order.
take back the 15,625 as you were not interested all this while.
Possession
Can't help
of the-
it. You can one morning 1993 this has happened, now you have come before the court.
After 1993, he had filed the first representation in 2011.
What were you doing all this while?
my lord, I have.
Are you alive?
Yes.
At what age did you get it?
75.
One thing very strange, you see, was this at any point of time? Was it the policy at that point of time that when you give it to the husband, you have to give it to the wife also? Because this
Well,
seems
that
to be in
was,
2019.
No,
Was this policy there then?
89 policy. my lord.
89 policy?
Land policy of 89.
Was it there? I don't think so. It has now been there.
In my lord, land policy tells the provisions that those who have, my lord, no land in the, my lord, urban areas, my lord, and the residings in my.
No, I'm not on that. See, in 2019 land policy has been brought in that when you give it to the husband, it also has to be in the name of the wife
My lord, it
for
is-
protection of the wife. That is there as per the 2019 policy. But was it there at that point of time? Because it's surprises how this policy document says so. Why it is given to both? And if it is given to both, why only the name of your husband has been given a copy to?
Only one copy to husband.
Why?
And wife's name is also not reflected in the order, copy of the order.
Because this is a policy which came in 2019. Isn't it, Mr. Hendrik? Revenue.
2019.
This policy was said to be by the government that we are doing something for the wife. And they had taken a lot of laurels on that aspect. That when we are going to grant an allotment, it will also be given to the wife also so that the wife's rights are protected. If that be so, what is the big deal then if it was there in 1989 also?
That may be another aspect also for reflecting the name of the wife, because, my lord, she may also claim after some time that she is also a landless lady. To protect
No,
that
I'm not
also.
on that. I'm saying in 2019, this policy wherein it says that the wife's name also has to be included.
Right.
was said with great pomp and glare to this effect that, you see, we are also thinking about the woman. And as such, this is the policy. See the some policy. Landless.
2019 policy. 2019.
See, number 18. Government shall continue conferring joint title to the husband and wife while giving allotment. So this was there earlier. Shall continue.
Joint patrol.
Now, how do you now bring this thing? He doesn't know which land.
My lord,
He doesn't know.
he doesn't. But possibly now it will not be possible because that dog was renamed, reclassified as so many different dogs.
Maybe, but he's entitled to one katha.
10 lakh.
10 lakh. You still have government land. Now those government lands have been allotted.
That is such like more.
Get your instruction.
Right.
List the matter again on 4th of October 2023. Mr. B.J. Talukdar, the Learned Counsel, appearing on behalf of the Learned Senior Counsel, appearing on behalf of the Revenue and Disaster Management
Not revenue,
Department.
my lord, 4, 5 and 6.
Respondent number 4, 5, and 6 shall obtain instruction as to whether there is any available land in
Old dog numbers.
the various available government lands in the various DAGs numbers, newly in the various newly in the various new DAG numbers which came into existence in the recent resettlement operation pertaining to old DAG number 687, the details of which have been mentioned in paragraph number 4 of the affidavit in opposition filed by the respondent number 6.
Right.
Get your instructions on. There, if there is any vacant land, we can allot.
Then,
That's all.
then that can.
That's
go
the
to-
only. Otherwise,
28.
yes.
In this matter,
What is this IA? IA for what?
TOT construction commissioning of the petrol pump set up by respondent number 6 violates the OM.
You are the applicant?
Yes.
Yes, what is it?
But also in this matter, respondent number 6 has filed their affidavit in opposition. We need a week to file a reply.
You want to file a reply? On the last occasion, you have taken time.
A week's time will be granted time.
Affidavit in opposition filed in 2021. You are enjoying a stay. Vacated stay.
There's no stay.
Okay. We admit it. However, as an intervener, respondent are directed to ensure that the provisions of the relevant guidelines are adhered to while issuing any NOC in setting up of the new petrol. You got the new petrol pump. You're running it.
Lordship, the
Happy?
commission has been done. It has been commissioned, Lordship. Later on, Lordship, it has been reconstituted.
No, now you're running it.
No, Lordship.
Why?
Lordship, there are some official process, some license is to be obtained, Lordship. That is why, Lordship, we could
Is
not
the
say that.
pendency of the writ petition having a bar on you?
No.
So we'll issue rule. Let it come after years.
I apologize, Your Lordship, so weeks time if granted.
Huh? You, 2021, they filed a writ petition, the affidavit in opposition, and you wake up in 2023. And you say that you require 1 week's time when the matter is listed before this court.
I apologize. A week time.
So there is no urgency in your part. Let them run it. This is filed in 2021 after 11 or 13 years. Let them reap the benefits.
I apologize, Your Lordship. A week's time kindly maybe.
This week's time is subject to cost. 1 lakh.
Cost.
1 lakh.
1 lakh.
The cost has to be given, no? Earlier also, matters came up so many times. You have been asking. You're not interested in the matter. The learning counsel appearing on behalf of the petitioner seeks for an accommodation of filing a reply. It is relevant to note a reply to the affidavit in opposition filed by the respondent number 6. It is relevant to note that the affidavit in opposition was filed on 14/12/2021. On 2 occasions earlier, the matter time had been sought for, but no affidavit in reply has been filed. Be that as it may, as the learned counsel appearing on behalf of the petitioner does not express any urgency in the matter, list the matter after 6 weeks.
29.
May I please, Your Lordship?
Yes.
This case, Lordship, petitioner was residing in a plot of land measuring 2 katta. That land belongs to Hindu Shoshan committee, and they provided me to stay here on that land. And accordingly, I have constructed a Assam type house along with the land, since 1970. Municipality board also issued a no objection certificate regarding stay over the land.
What is this land? Impugn letter, let us see. Where is it?
That letter, municipality authority issued the.
No. Where is that letter? 5/9/2020.
Yes, Lordship, that is page 26.
20?
26.
Annex of.
I don't know. Where is it seen that you have obtained or not obtained any permission for construction of residential property in ward number so and so, and whereas it has been constructed without following the provisions of so and so, because it can be to reply the underside following not be considered. Then what happened?
I accord on receipt of notice, I appeared before the municipality board and provided all the documents.
No, where is your reply?
I have not submitted any written reply.
Then?
I provided. The
Why should
documents
this
before the
court?
authority.
No, Mr. Bolvina, why should this court you were supposed to file a reply? Why should this court pass a status court?
Lordship, my specific statement is that I, on receipt of notice, I appeared before the municipality.
No. You were supposed to file a reply. You are asked to reply. Why haven't you done that?
Lordship, being a layman, I thought.
And being a layman, you don't know. No, Mr. Bhavya, kindly tell me, you being a layman, you don't know how to file a reply, but being a layman, you know how to file a petition.
No, Lordship, they instructed, Lordship, on receipt after instruction.
Oh, you go there, make a reply, give it to them,
Give me a chance, Lordship.
file a reply.
Lordship,
This court is not going to do that.
Lordship, in the meantime, their respondent may submit an affidavit in opposition. Lordship.
Why? Why is it necessary for them to submit an
Lordship,
reply? No,
Give me a
not
chance to
necessary.
submit a reply, Lordship. In the meantime, I may be protected, Lordship. It is the land where I am deciding the Hindu Shoshan committee. My father constructed house in 1970.
Mr. Bhavya,
Lordship,
if you say that you have constructed, I will assume that this particular document is a pristine document wherein it contains undisputed facts. And being an undisputed facts, you have also not submitted a reply out there. We will consider that it is an unauthorized construction. And as such, rightly, if they take an action, they take it right.
I have
The
not
only way out
constructed
is, the only way, Mr. F.U. Bhavya, is if you
I
file a reply within 10 days.
Lordship,
And not
give me
10, no,
that chance
I'll
may
give
be-
you 7 days. They have given you 3 days, I give you 7 days. And you have already got the benefit of 3 years.
Lordship,
I'll come
10 days
back.
time may be given.
2 o'clock.
Oblige.
Requisition or hired?
Hired.
I've taken on hire. the vehicles of the petitioners. During the period from 2016 to 19, and on the basis of which the petitioner claims an amount of rupees 1,26,58,516. The basis of the claim could be seen from paragraph number 5 of the writ petition, wherein the details of the bills have been mentioned. It is on account of non-payment of the said dues, in spite of the petitioner approaching the respondent authorities time and again, that the petitioner has approached this court under Article 226 of the Constitution. The record reveals that notice was issued by this court on 19/2/2021. And today the matter has been again listed thereafter. Mr. J. Hendrick, appearing on behalf of the respondent department, have submitted an instruction of the year 2021, which shows in the two instructions. An instruction of the year 2021, dated 1/6/2021, wherein it has been mentioned that various bills of the petitioner have been sent to the sanctioning authority for onward payment to the petitioner. He, however, submits that he has no knowledge as to whether the said amount have been paid to the petitioner in the meantime or not. The learned counsel for the petitioner also submits. Do you have any knowledge? Have you received any payment? The learned counsel for the petitioner also, however, submits that as per his instruction, no payment have been received by the petitioner. Be that as it may, the question as to whether the petitioner is entitled to the amount of rupees 1,26,58,516 or to any other amount from the respondents on account of the higher charges for the vehicles is a question of fact which would require the authorities to make necessary verifications. And thereupon, verification. This court cannot also, however, cannot be unmindful of the fact that if the respondent authorities have taken the vehicles on hire, the said amounts also cannot be withheld by the respondent authorities for withheld by the respondent authorities at its sweet will. So considering the above, this court therefore disposes of the instant writ petition, thereby directing the respondent number respondent number 4, either by himself or through any officer under him, to make necessary verification as to the entitlement of the petitioner. And if it is found that the petitioner is entitled to any amount, the said amount be paid to the petitioner. This court further clarifies that if any amount has been paid, the same would not be required to be paid to the petitioner. The said exercise be completed within a period of 3 months from the date of a certified copy of the instant order is submitted to the respondent number 4. The instructions so submitted by Mr. J. Hendrick is kept on record and marked with the letter X.
All right.
33.
Great pleasure, Lordship. Lordship, we are a spinning mill of the government of India, Lordship.
We're spinning mill lordship. We have been in litigation from last around 40 years lordship. What has happened lordship? We have got some land areas lordship, but due to land ceiling act lordship, some certain land has been deducted from me, and as on date, 212 bighas and odd were given in my name, which we have challenged in the process of 1976. Now that has been challenged in the year 2013 in this honorable court lordship. Lordship may find the order in annexure number 1 lordship.
No. What has happened out here? You are a tea garden.
No, lordship, we are a spinning mill of the government of India,
Hmm.
Ministry of Textile. Lordship, that I have been acquired, this company has been acquired long back lordship. And then due to the passing of the land ceiling act lordship, some certain portion of the areas were deducted by the in a land ceiling case lordship in the year 1976. That order we have challenged, it has been quashed lordship.
Section 7.
Lordship, yes,
Section 7 notification has been quashed.
quashed lordship.
Ah.
And in the year 2013. Subsequent to that lordship, we have been approaching that because that order is lordship will find at page number 20 lordship. They had to reconsider the application again lordship. Now what has happened lordship? We have been approaching them by giving representation for the reconsideration of the entire matter lordship. That has not been happening. Again in the year 2018, we have approached this honorable court. This honorable court was of the view lordship can at page number 22 the order which has been quashed lordship shall be there lordship.
Then?
Page 22 lordship.
No, it's okay. That is Justice B.K. Sharma's order.
Yes lordship.
What happened in 2018?
18 lordship, the same thing which is
I do so. I am opinion the return can be disposed the motion which I do by directing as the most particularly to enter to take note of the order and dispose of the matter afresh. The present petitioner shall submit up to and so copy and along with them within 10 days before the on receipt of the scan which depends of as directed within 3 months. Then
on within 10 days we have filed an application. That application was never acted upon lordship.
now what has happened?
So
It's
nothing
still
has happened,
pending.
lordship. Still pending.
The
Lordship.
orders passed by this court have not been complied with.
Twice lordship. Lordship, they have filed an affidavit also lordship.
What did they say?
Lordship, they have stated that the same thing lordship as per the land ceiling case number 364/76. Dated so and so the land measuring 202 bighas, 3 gutters, 9 letters covered by so and so has been corrected in favor of National Textile Corporation by order by office dated 2005.
So nothing remains.
Nothing. No, nothing happened, lordship. This has been quashed, lordship. This order has been quashed. 16/7/2004 has been quashed already. Now the deputy commissioner.
No. From whom the land was acquired, taken under the Ceiling Act?
From us, lordship.
You mean?
From the Associated Industries Spinning Mill, lordship.
You were the owner of the land?
No. We have purchased it, lordship.
From?
From a private party, lordship.
Then why the matter land has gone to Textile?
We were acquired, lordship. We were acquired by the government of India. So as per the Land Ceiling Act Section 2, the Land Ceiling Act is not applicable to a government agency, lordship.
No, understood. Is your company still in existence?
Yes, lordship.
Were you acquired by the
Yes.
government of India?
Yes, lordship.
Once you are acquired, then what happened? What remains?
No, lordship. Lordship, when they have acquired us, lordship, the Land Ceiling Act will not come into force against us.
Forget about Land Ceiling Act. What is your status? Who has acquired you? How your company was acquired by National Textile by the government of India?
Lordship, may kindly see page number 4, paragraph number 1, lordship.
Is the government of India undertaking and was the unit of the
In page number 6, lordship, as per
was a subsidiary of Iman, was nationalized by the government merged with so and so by sorry. You have merged with NTC.
I was nationalized, my lord.
Forget about that. You say which has merged into NTC Limited by BIFR approval.
Yes, my lord. By SIC Textile Undertaking Nationalization Act 1974 on 1/4/1974, lordship. In page number 6.
Paragraph number 1.
Page number 6, lordship.
Page number 4.
Page number 6, paragraph number 4.
Page number 4. Paragraph number 1.
Lordship.
Fourth
Sikh
line.
Industries, as per nationalized, Lordship, I just read Lordship, was a unit of National Textile Corporation, West Bengal, Assam, Bihar, Orissa Limited, having its registered office at 7 Jawaharlal Nehru Road, Kolkata, which is a subsidiary of a National Textile Corporation, New Delhi. And the petitioner company was nationalized by the Government of India as per the Sikh Textile Undertaking Nationalization Act 1974.
Then thereafter, which has merged.
Which has been merged into NTC Limited by BRFL approved.
So as of now, you don't have existence. It is the NTC.
It is the NTC. Lord.
So now this has now been corrected in the favor of NTC.
Yes, Lordship, we are the NTC, Lordship. We are
So-
running this.
What is wrong?
No, Lordship, it is with regard to a property dispute. That land belongs to us. Now the
No,
property,
they belong to whom?
the NTC, Lordship.
NTC is not before this court.
Yes, Lordship, this associated industries, we have been run by the NTC.
Do you have an existence after the merger?
We are a subsidiary company, Lordship.
Do you have an existence after the merger? How can you have an existence after the merger?
No, my lord, that is what, Lordship, this National Textile Corporation has acquired us, Lordship.
Understood. Do you have an existence thereafter? No, you can't. After a merger which has taken place, you have already been merged. This is the scope of amalgamation.
Whatever, my lord, now the NTC owns the land, Lordship.
So it is now corrected in favor of NTC.
Lordship, that is what, Lordship, 202 because is not our land, Lordship. We have purchased around, Lordship, 586 plus because of land. Out of that, only 202 because were given in our name, Lordship. And we are not subjected to land selling case, Lordship. And that question has to be decided by the Deputy Commissioner, Lordship. Now, Deputy, there's a specific.
Understood, Mr. Everything I am, but do you have an existence?
My lord, as per me, I have an existence.
How?
Because we are running.
If you are merged with the
If
company,
not-
with NTC, how do you have an existence?
But this is the NTC, Lordship. NTC is running the mill, Lordship.
NTC is not before this court.
NTC is before the Lordship.
Where?
Lordship, may kindly see the cost ID.
Let us see.
Messrs. Associated Industries, Assam, Spinning situated in Chandrapur in the district of Kamrup Metro, Assam, a unit of the erstwhile National Textile Corporation, Kolkata, which is a subsidiary of the National Textile Corporation Limited in the New Delhi, represented by Manisha Das, daughter of so who is working as a assistant manager, cost and accounts, National Textile Corporation, RMD Guwahati.
As of now, do you have an existence?
Lordship, that, okay. As per
I
my
don't
humble
think you
submission,
have an
the
existence.
National Textile Corporation is the owner of the land, Lordship.
So if National Textile Corporation is the owner of the land, do you have an existence to file a writ petition?
Lordship, as per Annexure 22, Lordship.
Annexure?
Annexure A, page number 22, Lordship.
That's an order passed by the court.
Yes, Lordship.
But this
Writ
court
petition-
didn't ask that specific question then. Now should this court shut its eyes in respect to a person which is not in existence?
My lord, this associated industries, Lordship, that is a terminology, my lord, but it has been run by the National Textile Corporation.
Mr. Dekka, kindly appreciate one thing. Whether you have an independent existence. Do you have an independent existence after the merger?
So that I'll have to check, Lordship, because according to me, I have, Lordship, but
Show me that even after the merger, you can have an independent existence.
sir, I'll get back to you, Lordship.
At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after the puja vacation.
I'll look.
34.
Maybe.
Hmm.
Lordship, we want to withdraw this petition. Because, my lord, the petitioner has executed the work.
You want to
my lord.
withdraw? The learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition.
With the liberty.
Liberty why? What is this liberty business?
My lord, the petitioner has come, my lord, actually the petitioner has applied the materials, my lord, through a vendor's license. It is the right of the vendors only to approach the court, my lord.
Then what is the liberty you are asking for? Why liberty?
This new petition,
Why? That means you filed the petition in 2021.
21, my lord.
Then
But it has clear now, my lord, that the petitioner is the individual, my lord. So he has not right to file the petition. The
Yeah.
petitioner has executed the work.
you may have a liberty against the vendor,
Yes.
not against the state. The learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition in view of the fact that the petitioner does not have a cause of action against the PNRD department. The learned counsel, however, submits that the petitioner's cause of action is against the vendor, which would be a private dispute for which the petitioner may be permitted to avail remedies against his vendor. In view of the said submission, the instant writ petition stands closed on withdrawal. It is made clear that the withdrawal of the instant writ petition shall not prejudice the petitioner to avail such remedies against his vendor, if otherwise permissible under law.
35.
Yes. Mr. Bhattacharya.
Yes. We have no contact with our client, Your Lordship, for long.
What is this matter?
Matter, Your Lordship, is her patta has been cancelled under Rule 26 of
Patta cancel.
Contempt.
Why are you here?
Since Your Lordship, as per Rule 26 itself, before clear that Your Lordship, a notice is to be given to the petitioner. That has not been given.
This is our annual patta.
It was an annual patta, Your Lordship. What has happened then? He prayed for, submitted an application for conversion to periodic patta. That was allowed, Your Lordship. And then amount was directed to be deposited, Your Lordship. He deposited and patta was issued. And then Your Lordship, when he filed RTI regarding that, he came to know that they took 2,25,000 from them in the office of the additional deputy commissioner and deposited 90,000 to Salan. That is the source. But ultimately, she found that that Salan has also not been, in fact, submitted by these people. And she herself filed a complaint before the authorities saying that there is some discrepancy in the entire matter. Looked into it. Ultimately, there is an inquiry, and inquiry found that Your Lordship may kindly come to the order, Your Lordship, at page 36.
So this patta was cancelled.
Cancelled, Your Lordship,
Then
under Rule 26. Then Your Lordship, Deputy Commissioner passed the order, Your Lordship. Then I came before this honorable court. Notice was issued, Your Lordship, the authority. The government did not file any affidavit. And Rule 26, it says, Your Lordship, that subject to the general control of the state government, the commissioner shall have the power to confirm all settlements and also to cancel any settlement made in contravention of these rules after giving the.
you are annual patta holder.
Yes.
You are still in possession.
I am in possession.
Okay, that was converted.
It is converted.
That conversion is bad.
Bad.
Why is it bad?
It is bad, Your Lordship, the deposit, the premium has not.
No. The reason is not that. The
Lordship.
reason is that The conversion was done without following the due procedure.
That is there.
So then what?
But your lordship, what procedure they have adopted? These are the things, your inquiry report that has not been furnished to me. Since the rule provides that I should be given an opportunity, that opportunity should have been given to me, and that inquiry report at least should have been provided to me so that I can object it to the decision, your lord. Ultimately, a decision has been taken, your lordship, to convert. And pursuant to that, your lordship, whatever action they have taken, your lordship, that's bad. I have applied. If they have not followed the rule, your lordship,
You don't get a right. You get a right.
but your lordship, if they have, since they have applied the rule 26,
No, they can do it afresh if it is not followed.
lordship, that's what your lordship.
No, but the fact that the patta which was issued to you was based upon the deposit.
Yes, your lord.
Who have not deposited.
I have, your lordship, deposited as a lord. I have.
That was
I
not
have- that
deposited.
was not-
So you have not been issued the patta.
My application is still pending.
So it will be deemed to be pending.
Lord, deemed to be paid. Let them take a call on that. If in the meantime, through Vasundhara, he has not got that, your lord. Because your
I think because as of now, the question of the cancellation of the patta without notice means you have not become the leaseholder in respect to that. So what to do? You give a suggestion.
lordship may dispose of.
Keeping the matter pending is not going to help you.
Let that application be considered by them. Pending.
Yes.
application.
His status will be as of today, my lord,
Hmm?
that of annual patta holder. So he can apply now.
He has applied,
He has applied earlier.
but
he has
wrong,
not
but
deposited
there were some mistakes committed.
Right.
The question here, he is alleging that you have cancelled the patta without giving me a notice, the periodic patta. The fact that the periodic patta was not issued to him, taking into account that he has not deposited, there was something wrong.
Right.
Where he can very well allege all these things, that's a different aspect. But the fact that you have a policy for conversion of the annual patta to periodic patta is already there. So
Right.
under such, don't you think that you need to bring to a logical conclusion the application file by him?
But keeping this petition pending here will not,
That's what I.
may not
also
solve
suggested.
purpose because
Mr. Bhattakuri is also not on that.
And we could not communicate because he did not serve the copies.
Mr. Bhattakuri, this is absolutely uncalled
From
for.
2019, probably. your lord.
From 2019, this thing is pending. 2021. Order is passed in 2019.
Lordship.
You file in 2021.
Number of times this case has come up, but they.
No, we have pointed out in 3/6/2022.
Huh?
3/6/2022, the matter came up before this honorable court. And we have pointed out that extra copies were not served.
Here is the- this one I don't-
I think the best way is that is the only way out. We won't touch on that.
Right.
The cancellation is okay, but whatever may be, you have a policy for conversion.
Right.
And in view of the recent policy also,
Recent policy. In land policy also it is there.
recent conversion here. As no new annual patta shall be issued, all annual pattas land fit for conversion shall be converted to periodic as expeditiously as possible by chalking out a time-bound period as per it. There shall not be any restriction to convert annually in town for individuals with respect of area if otherwise eligible. So this is already there
It is there.
as per clause 11.
New land policy.
I think that is the only way out. The incident with petition has been filed by the petitioner, being aggrieved by the order dated 5/8/2019 issued by the Commissioner, North Assam Division, Tezpur, whereby the patta issued in favor of the petitioner was cancelled, as well as for appropriate direction against the officials involved in illegal act, including the additional Deputy Commissioner Revenue, as per law, by investigating through an independent agency, etc. The record reveals that the petitioner where's your application?
Application is not there, but your lordship, the order starts at annexure A, page 15.
Annexure?
A, page 15, your lord. There is a case registered, your lord.
There is no dark number, nothing.
Doc number 152B,
You are in possession.
lordship.
Where is your statement? Or that Exona Patta was issued in your name.
Lordship.
Where is it?
The petitioner is presently residing somewhere locality in her residence. It is further presented. Submitted application before the circulation for 16 where she is staying with her family and sending duty received by the authority contract. That is the statement of para 3. Tag number
Very difficult nowadays. Is it because of urgency the entire details have not been put by you?
lordship,
Don't you think that a bit some more
Lordship,
seriousness is
Lord-
required?
lordship required.
Somebody's property is at stake.
Lordship.
List the matter. Mr. B.J. Talukdar, the council, senior counsel, appearing on behalf of the appearing on behalf of the
225.
respondent numbers 225 submits that no extra copies of the writ petition has been served upon the petitioner, upon the respondents. The petitioner is directed to serve extra copies of the writ petition by today's what? By 14th of September 2023. Full stop. The petitioner is also directed to bring on record any document which should show that the petitioner was holding any annual patta in respect to the land.
The application I had, I will file.
It is not there. You should have. List the matter after 4 weeks.
36.
Yes, you file affidavit.
Affidavit not filed, lordship, but I have received the signed copy today only, lordship.
Oh, that one.
Yes.
In front of that.
Yes. Overground pipeline, lord.
What is this?
That sketch map is there, lord.
You have filed the affidavit? No.
affidavit I have received the signed copy today only, Lord.
You're filing it.
We are going to file
I
it.
think better off. Mr. P. Nayak appearing on behalf of the respondent submits that the affidavit could be filed during the course of the day today. Just list the matter again on 22nd of September.
22nd, Lord,
Right.
I'll be out of. 22nd, I will be out of.
20.
Thirty-seven.
May I please tell
Hmm.
Lordship,
Who is you paying for BTC? Yes, what is your case?
Lordship, this writ petition is filed for a direction to the Respondent Authority for demarcation a plot of land measuring 2 kathas 7 left under tag number 604 and patta number 21.
Yes, then what happened? You have written it to
My lord, petitioner
the revenue circle officer at Boroma.
Boroma.
Then what happened? Why are they not mutating? Means demarcating. Today also none has appeared on behalf of the BTC.
Their name not been reflected in that list.
Who is appearing for the Deputy Commissioner Baksa?
Lordship.
Vinayak is appearing, your lordship. Your lordship, name has not been reflected in the cause list. So we had skipped the matter, your lordship.
Understood, but it is a simple question. Why these matters are unnecessary? If he wants a demarcation, if you want to consider it or say you don't want it. But you can't keep a matter pending like this.
Lordship,
On the-
disposal, my lord, I can give a direction, my lord, to demarcate the land.
Why should I? Means I can very well direct, but there must be some good reason why you have not acted upon it.
Lordship, my lord, the one instruction I have received, my lord, that from the additional deputy commissioner.
What does he
They
say?
have said that, my lord, it is transfer subject of the BTC.
That is why on the last occasion the BTC was not represented. I mentioned it.
Will obtain instruction, your lordship, in this regard.
Miss
your-
Pidas,
He does.
appearing on behalf of the BTC, submits that she requires a week's time for obtaining the necessary instruction as to why the petitioner's request for demarcation of his land have not been acceded to by the respondent number 3. List the matter again on 29th of September 2023. The learned Ms. Pidas, the learned counsel appearing on behalf of the BTC shall apprise this court on the next date the reasons sought for. The apprise this court as to why the petitioner's applications have not been acceded to. The registry shall also indicate the name of your BTC counsel
BTC council,
or delegate of Mr. Pina.
BTC council, your lordship.
Ms. Pina, so the name of Ms. Pidas appearing on behalf of the BTC in the court.
Deeply obliged.
38 and 39.
My lord, this matter, Lordship had directed us to file an affidavit. My lord, this affidavit can be filed only today. It was ready before long time. Some issues at the filing section, my lord.
You filed it?
I have given him a copy also.
Okay. Mr. D. Gogo appearing on behalf of the Excise Department submits that the affidavit on behalf of the Excise Department has been filed today. Mr. J. Roy appearing on behalf of the senior counsel appearing on behalf of the petitioner submits the 2 weeks time may be granted for filing a reply. List the matter again on 9th of October 2023. Interim order passed earlier shall continue.
My item number 38, 39, 40 and 60.
Huh?
40 and 63.
Same matter.
38,
Same.
same matter. 38, 39, 40, 60.
Affidavit be filed by,
We'll file it in a week, madam.
you are filing it today?
No.
Only one
No,
day. Fine.
one has come. Another, madam, 3 matters are there. Same is 10, but I require another week's time, madam.
No, there I'm not giving it anything. There I will take it. Which one did you file?
38.
38, madam.
Sanjay Sarkar.
No, Rupam Goswami.
Rupam Goswami te to order.
Ah.
Sanjay Sarkar, they have not filed. So we'll take it up for disposal on the basis of the materials on record. That's
And also, madam, there was a direction to make finance a party.
Huh?
Finance has a necessary party because we are agreeable. We want to condone this. It has been written to the government.
Still we are waiting for the affidavit matter. And if necessary, we'll make the, we'll file it application within 3 days.
which one?
They want to make finance as a party.
Who wants to make finance as a party? Why will the Department of Excise will make the finance a
No,
party?
my lord, because it was my lord had undergone one.
I know that, but
Yes.
I know that this is the finance department who says that on account of COVID, this amount should not be
Yes.
reduced. I know that. But that doesn't mean that the respondent is going to ask that to make finance a
No, no,
party.
I'm not asking.
No,
I'm not asking. My lord,
it is
it
your
was-
duty.
It has.
And if it is not done, we'll dismiss it on that ground itself. Let us see now. Rupam Goswami goes, we are adjourning it. The others, he has not filed his affidavit, so we'll take it up for disposal now. Tell me. Argue?
Well, let it be a-
Argue?
Well, I have not prepared my lord.
Okay, we vacate the interim order.
Let it be on 9th, my lord.
Why should I? Okay, I'll pick this on 9, vacate the interim order. Argue?
My lord, 50.
You have a case where there is no reply. So we will consider this without, because there is a specific direction by this court for asking him to file their reply. They have not filed it. So we will take it on a doctrine of non-traverse. Now you have a clean slate. Why you are not going ahead?
The lordship may see my lord, page 26.
But the only problem you have is the finance is not a party.
With that-
And if the moment he says the finance have done it, you have the problem.
That's what I will take to the party.
So we vacate it, the interim order. Because without the finance, how can you proceed with the instant petition?
My lord, so far, my lord, it's in my. Let
Yeah.
it,
I understand your case, I have no.
I'll file it.
This is on the dead stock.
That's all.
Let's stop, my lord.
Unsolicited.
This is on the dead stock.
I-
So the commissioner of excise is in your favor. So they will obviously give an affidavit in your favor. Stating entirely, yes, this is dead stock which cannot be sold.
That's all, my
Then
lord.
how do you take care of the finance? But they have not done it only because of the finance.
But this is. the-
Why haven't you made the finance a
My
party?
lord, the stand has come now, my.
Huh?
By filing the affidavit in that point.
This is not there. Everybody knows about this. Whoever the lawyers who have been appearing out there for your clients. These people, they always know because that was what I have recorded in my earlier orders.
That is,
Then
but that is. But
why
I'm aware
haven't you
of.
made the finance a party?
I understand, your lordship. Allow me, my lord.
Because it is the finance who have done all this thing. He has written such a good recommendation, the excise, that to the state, kindly don't take it. It is dead stock. Where will these people go? You are not there. He is not that finance. This is the Mr. B. Gogoi Finance. Finance and taxation.
Let it be on 9th, my.
Hmm?
Let it be on 9th
For
for disposal, my.
as of now, we can dispose.
But then finance again, if it will. my lord.
We dismiss it on the ground that finance has not been made a party. No effective relief can be given. You are asking that the amount of rupees 71,73,354, which is to be deposited pursuant to a direction issued by the Finance and Taxation Department, and you want to stay without the Finance and Taxation Department as the party.
Right. Let's take up.
Hello? At the request of the learned counsel for the petitioner, matter stands adjourned to 9th of October. Right. Hey, I got to take to order, but hey, I'm looking at the file. Hey, put it on 9th of October.
All right.
I'm not extending the interim order. You don't have a case. It's okay.
I'll say, yeah.
He is not entitled to. Then in that regard, he has to indemnify.
Yes, that will be a civil liability. My lord is correct. Now, to fix up that civil liability, if we go for regular civil suit, it will take time. Now, let me explore whether.
That is another thing.
Yeah.
But the fact that you have to pay to them,
Yes.
how do you take care of
Burden
that?
is on us. I will have to recover it. Otherwise, my lord,
Now, why should this court take into anything pertaining to you? You have done a mistake with him, or your person may be in hand in glove with him. You must have done something to that effect. And thereby you are admitting out here that thereby directing him to refund the amount of this 22 lakh.
no, that is one way of doing it, my lord. But
That is the only way which I am seeing.
otherwise, my lord, one way which I may contemplate, subject to my lord's correction. Now, my lord, fact remains that R5 has, my lord, taken the money. R5 has not yet filed the affidavit. Definitely, R5 will bargain time. Now, my lord, since he is in a happier position, now lordship may kindly give a short that for R5 to file an affidavit, because it will be on affidavit on oath before this honorable court.
He is not going to file it.
No, if he doesn't file, lordship
I
may
can compel him.
yes, lordship can compel his personal appearance here.
Why should I?
So then, my lord, he will.
No, the burden is you.
The burden is on us, but
Payment burden is you. You are to pay. Why should this court take any action at your behest?
no, that is true. Yes. So therefore, no, yes. But then again, my lord, going
You
for
file
regular-
criminal case against him, you do whatever you feel like do. If he has not, there is a specific order passed by you.
Yes, there is a specific order.
Yeah.
A specific order. And in fact, it is the admitted position on record also, that he has taken the money. Now, my lord, I was just going through the provisions of section 3I of that 1956 Act. But 3I have the power of a civil court only with regard to till the stage of determination, my lord. It may not be post-determination.
You see the question of 3H.
3H is there. 3H
3H is as regards the apportionment.
apportionment.
But these are all prior to.
Yes. Now,
Prior to.
yes. So
Now
there-
you have already
3H
released.
Yes.
If you have released, now are you saying that he is not entitled to?
No, it's not it.
If you are saying he is not entitled to, then you are to make a reference to the
No,
under
it is
3H4.
civil code, that is 3H4.
You have to make a reference to
No,
that
that-
if he is
that's-
not entitled.
No, that stays,
But
my
if
lord.
you are saying that he is entitled to,
Yes.
then it is your burden to pay because you have acquired his land without making a payment.
Yes. No, therefore, my lord, I was making that submission.
You want another chance to be given to the respondent number 5 so that he owns his response. I remember when the matter came up earlier before this court, I told him that what will happen now? Then Mr. J.K. Gustami came running from there without knowing what has happened. And he said that I'm going to file an affidavit.
No, my lord, affidavit is fine. Now we have to find a way out.
Now he has found out the way out after seeing the court proceedings, what has actually happened.
No, now definitely the burden is on the Kala, competent authority. Now, my lord, if we, that indemnity bond, my lord, that I am not having, if there is something in the indemnity bond that criminal jurisdiction, criminal court jurisdiction can be attracted, then
No,
definitely.
you see, the indemnity bond content is that if anything goes wrong with the land
He will
or
have to
regarding
return.
the compensation, he is going to indemnify you.
Now, if he doesn't do so, there is a case of clear violation, as we have now, till now.
No, then you can have many other sections which I need not point it out to
Yes,
you. But the fact that the petitioner is entitled to, there is no quarrel with the position.
yes. Lordship can then dispose, my lord, directing my lord him. Because I was just seeking some time from my lord to explore whether my lord, I can initiate immediately Bakizai proceeding against him or not. Under the,
Bakizai proceedings would be obviously you can,
yes,
why not?
because it will come within the ambit of a public demand. If it is a public demand, then it will be a shortcut method. If I go for a regular suit, I am the color, I am
And
filing a.
Bakizai proceedings also enables you to arrest him,
Yes,
attach his property.
yes, yes, yes. It is clearly a public demand. There is no escape from that. If it is a public demand, then R5 will be in trouble. Now, how soon we can put R5 into trouble? That is the question. Lordship can dispose of my lord. Directing my lord, Lordship can
No,
specifically direct my lord.
This is not to be disposed of. It has to be done in this manner.
My lord.
The respondent number 5 had given an undertaking before this court on 14/8/2023 that the affidavit will be filed within 2 weeks. Accordingly, this court fixed the matter on 11/9/2023. However, the respondent number 5 have not filed an affidavit in opposition on the ground that there is no instructions received from the respondent number 5. Be that as it may, list the matter again on 11th of October 2023. In the meantime, this court, the pendency of the instant petition shall not bar the respondent authority to initiate appropriate proceedings against the respondent number 5, against the respondent number 5 on the basis of if so permissible under law. But I think this is the best.
Then therefore, my lord, because we have to compel him. I am so obliged.
Item 43.
Yes, what is this?
Regarding no confidence motion, my lord. Yeah, my lord, the no
Is
confidence.
this the same matter or the earlier matter? Just now,
Earlier matter, man. Earlier matter, man.
just now I was
Yes,
taking his junior said that he had no file.
My lord.
Okay.
I provided my petition, my lord.
Now let us see. His basic case is that 14 days has not, 15 days or 14 days have not.
And he was not served. That was also case.
And second point, my lord, the notice of meeting, my lord, that was issued by the executive officer.
Huh?
He has no jurisdiction, my
Notice of?
lord. Meeting, my lord, page, my lord. Page 28, my lord.
Page
28. This notice is also, my lord, without jurisdiction. These 2 points, man.
who has to issue?
Executive officer of Ropri Ansulik Panchayat, my lord. Meeting ought to have been, my lord, convened by the president as per Panchayat Act, my lord. And in this point, my lord, the honorable division bench held that, my lord, the executive officer has no jurisdiction to issue notice.
Okay, let us first see the requisition submitted.
Lost.
On 28/5/2021, Secretary placed the requisition before the Gram Panchayat President on 2/6/2021. Via refused on 11/6/2021.
That page I have prepared, my lord.
Huh?
That page I have prepared, my lord.
Okay. Secretary forwarded on 14/6/2021. So your case is what?
My case, my lord, section 15(1), my lord, no copy has been, requisition has been furnished to me, my lord. And second, my lord, the notice issued by the executive officer.
That we'll consider.
Lord,
Now,
that-
you'll hold it. You now have the copy of the requisition.
Lord.
You
No,
held
my
it.
lord,
15
I
days.
think, my lord, they have already settled, my lord. Only the members, my lord, I think they have already compromised, my lord. I don't know, they are not representing also, the members, my lord, although their name has been shown.
Whatever may be, this matter has to be brought to a logical conclusion. Your only thing is that, so we'll dispose it of directing you to hold it within 15 days, failing which on the basis of this. If you fail to do so, then the matter will be.
May I submit for
Yes.
two queries, my lord? First, my lord, there is a postal office, my lord, that he refused to accept by the secretary, my lord, via speed post, send the letter, my lord, forwarding letter, and there is an endorsement from the postman that he refused to accept. She refused to accept. That is for first, my lord. And for second, my lord, the executive officer, he is the ex officio member of the Ansalik Panchayat, my lord. So he issued on behalf of the president only, my lord. The secretary, the executive officer, my lord,
Section 15 nowhere
is
empowered, my
the
lord.
ex officio member of the Ansalik Panchayat, my lord.
And they have filed an opposition.
By the respondent, my lord, maybe. Private respondent.
Lordship, actually, I have already given a NOC to the clients, your lordship, to respond number 7 to 13. I have returned a brief of the case, your lordship.
You have handed it over.
Yes, your lordship.
So they know it that their matter
As per
has
my
to be.
instructions, there's a compromise talk going on between the private respondents and the petitioner. At that point of time, I have issued this NOC on 8/1 of 2022, your lordship, and I have returned the brief.
May I submit, my lord? If, as per Panchayat Act, my lord, if once a special meeting held and president is out, there is no provision for compromise, my lord. Once out, then he out, my lord. There is no provision for compromise. If the special meeting is valid, thereafter no compromise.
But there's a stay.
Yes, my lord. Stay is there, but
So because
up
of
to
the
that,
stay, now the compromise happened.
my lord, but stay is up to that, my lord, aspect, my lord, that he was not received the letter from the secretary, which is not correct as per the record, my lord.
No, it's okay.
My
But
lord,
they just stay to the effect
my lord.
that in the interim till the returnable date, the impugned resolution dated shall not be given effect to.
My lord.
Then the interim order has been extended from time to time. Interim order extended. That's all.
My lord. But
So that is why now he has in view of the stay, he
Well-
continues to be the president.
oh, yes.
So these people, the other
They are
7 to
not
13
representing
must
right now,
have
but-
got fed up with Mr. Bordlowitz and taken the file from him.
But they are not filing affidavit there that they are compromising.
No, they have filed affidavit.
File-
Opposing his case. They have filed affidavit.
Opposing,
Yeah.
yes. But there is no affidavit saying that they are compromising with the petitioner.
Understood. So they must have now, because of the stay being granted, and the period is ending in December. So that is why they are not doing anything.
Private settlement.
Private settlement.
But it's as per in the eye of law, it's not valid, my lord. That is why I am submitting.
So
Otherwise,
the
I will leave
fact
it to your lord.
that it has been refused,
Yes.
if it is refused, then the period does not
It
have
has
any
gone,
effect.
my lord. As per Mosira Bibi case,
Where is that?
there is a postal.
Return to the sender.
Yes.
Date will be,
Reason is the
Secretary.
date will be relevant.
Return to the sender. Return to the sender if it is so,
yes. That means he refused to accept.
but where is the endorsement?
There is an
11.6 item return refused.
yes. my lord. Once she refused her right, my lord, for 14 days, she waived her right, my lord, as per Mosira Bibi case, my lord.
Pending requisition, my lord, by postal, my lord, is unknown to Panchayat Act.
Huh?
It should be, my lord, personally served. not by postal method, my lord. Section 15, Ali Ahmed case, my lord.
That was placed before her, my lord, but she did not take any action. That is why she, the peon, my lord, the secretary, my lord, then via speed post, alternative delivery, my lord.
Ang Panchayat Act.
What is the move? नहीं नहीं अच्छा now okay compromise by the board
Where it is mentioned that the president of the Gaon Panchayat, Anchalik Panchayat has to issue the notice?
My lord, section 15, my lord.
Yes, let's see.
My lord, such a meeting shall be specially convened by the secretary of the Gaon Panchayat with the approval of the president of the Gaon Panchayat.
Where is it?
Section 15.
this
my
is
lord.
the initial part
Initial part.
Where? Such a meeting shall be specifically convened by the secretary of the Gaon Panchayat with the approval of the pensioner. That is okay. Then
Next, my lord. Such meeting shall be presidable by the president if the motion is against the vice president, and by the vice president if the motion is against the president.
Hmm.
In case such meeting is not convened within 15 days from the date of receipt of notice, the secretary of the Gaon Panchayat shall within 3 days refer the matter to the president of the Anchalik Panchayat, who shall convene the meeting within 7 days from the date of receipt of the information.
so does it mention require that
Now,
he has
this-
to issue the
My lord,
notice?
in this point, my lord, honorable division bench, my lord, held that, my lord, a meeting should be held by the president, my lord, and executive officer has no jurisdiction.
To issue notice?
To
Hmm.
issue
it's notice no meeting over
issue notice for meeting.
Show me that.
My lord, today, my lord,
Show me that. That is a relevant thing. Huh?
lordship. And on this point, my lord, this all court granted stay. my lord.
Huh?
The first day also, my lord, we take this issue, my lord. Secondly, my lord, if the postal is returned on 12/6, he referred on 14/6. That is also, my lord, not 15 days. Only after two days he referred the matter as per their own document.
refusal is there, my lord.
Mr. Datta, why should we go into all this thing? Let him hold 15 days.
My lord.
Let him hold within 15 days. Matter ends there. Isn't it?
That is there.
As of now, he knows there's a requisition. If he does not hold it,
But he already compromised with the private respondents.
understood, if he has done it, neither you nor he will do anything. Now everybody is in
Problem
hand
that,
and
my
glove.
lord, I'm just asking myself, my lord. The problem is that if lordship will allow this repetition, then it will become a normal practice to others also. That after losing the no confidence, they will manage outside the court, and then false case will file, and they will compromise. In that case, section 15 is nothing, nowhere required.
Understood, but what right do you have?
My lord.
Means how are you affected?
I am just in the no confidence motion, my lord. I am appearing like a amicus curiae only because, my lord, it's a conflict between the elected bodies.
The only thing
My
is,
thing is the
Mr. Datta, only thing is whether the panchayat GP
my lord.
enjoys the confidence of its member.
That question will not come for us, my lord, as a being in the department. My job is to just protect the law, my lord, to correctly place the before your lordship, my lord.
We get a many cases out here
My lord.
wherein we see that this is good. Because you see now, just for example, admittedly, on 14 or on 11, a document was sent by the register,
My lord.
by the secretary.
Secretary.
He did not open it.
Yes.
He does not know the contents as you could see.
My lord.
So it may have been, he may have refused some others also. How do you presuppose that he knew that it is so and so?
It is also there, my lord.
Now the second question is, just for example, the moment you serve upon him, doesn't he have the right to change his mind within 15 days? Or
That,
he has no?
that option dealt with the division bench in Mosira BB case, my lord. If refused, then waived their right to 15 days, my lord.
But that is only when he knows.
Yes. She knows, that is why she refused, my lord. That
How
is
does
I'm-
he know
I'm
that
just-
this is being issued?
Because that was separately placed before her also, but that was, see, they didn't, any endorsement is there, my lord. That office note is also there. First, he say the secretary placed before her. When she didn't take any action, he by post he sent, my lord. I leave it to your lordship, my lord. Just I'm informing the facts and
No,
law
see,
provisions of
the only thing is, I understand what
Right.
you are saying.
Right.
That, in fact, every time this happens,
Yes,
the problem happens when you give a stay.
yes, my lord. Otherwise, stay is very difficult, my lord.
If you give a stay, this is going to happen.
My lord.
The effect is, the other side will obviously compromise. Because they know now the stay, how many years the matter
Yes.
goes on, you never know. Now this matter has been the stay has been granted in 2021.
If they can continue 3-4 months, the matter
Matter is
become
over.
instructions.
So what is there?
I leave it to your lordship,
So
my lord.
only ends of justice. That is why I say, let him do it as he have noticed now. Enjoy the confidence within 15
My lord.
days.
My lord. My lord.
And if he does not, it will automatically, 15 will take effect. Then they will also realize they may not, their compromise may finish.
She will be very happy
Huh?
with the new meeting, my lord. Fresh
Oh.
meeting. The petitioner, my lord.
A petitioner would be happy, but the fact that, you see, the problem arises is, if there is a division bench judgment to that effect as regards the executive officer,
Right.
it is the president who has to call. In my opinion, is different.
Yes.
It has to be by the president, the executive officer, who is also the officer of the PR. He could have done so on
Yes.
behalf of the president also.
Being
It
the
will be
action-
deemed
Yes.
that it has been done at the action of the year.
Yes.
But the problem is, I have looked into that notice also. That notice does not say that on behalf of the president I have done it.
I also checked that, my lord.
If he had done that, I would have very well hold it. But there the problem arises. He should have mentioned at least one word.
Right.
On the other hand, the notice, a copy is being given to the president.
Yes, yes,
Read it. In the Assamese version, you'll get
my
it.
lord, yes, yes. Wait, wait, wait. Yes.
He should have, the executive officer ought to have written out there that the president convened and I'm issuing the notice. Should have done that.
Copy mark to the CEO, my lord. Not the president of Anchalik Panchayat.
But anyway, have a look at the president, the document. Does it say anywhere in the in the vernacular that at the behest of the president he is issuing? Not
My
in
lord,
the English.
in the record, office note is there, my lord. President's of note is there.
Where?
Directed, my lord. In the record, my lord. There are some legal papers, my lord. Legal sized paper. The below one, my lord, is the note of the president, my lord. He directed the executive officer.
No, it is there.
Yes, my lord. That is there, my lord. After that direction only, he issued this, my lord, being the ex officio member.
When did he issue?
Issued on 15/6/21. And he referred the reference number is also there for 14/6/21. Oh, 14/6. Reference given.
When did you receive it? The Anchalik Panchayat receive it?
On the same day, I think, my lord.
It was sent by again speed post?
No, my lord.
Yes. The secretary sent it on 14/6/2021 by post.
Yes, my lord.
Then there is another communication where it is written dated 16/6
Right.
to Mrs. Rehna Khatun, President of Toronto. How did these people know on 14/6 itself and received it?
Can I go through it?
Yes, yes, please. This is very relevant. Yeah.
Secretary forwarded on 14/6.
By?
By directly, my lord.
How do you say so?
This
Because down below it says some post.
Post to only the Gaon Panchayat Secretary President, my lord.
Then it will be there in the peon book.
Peon book. This is the peon book of Anchalik Panchayat, not the secretary, my lord.
Is the but how do you show that? How was it directly given on 14/6?
my lord. 14C, 14.6, my lord. Secretary forwarded, my lord. Then this is the signature of the Ansalik Panchayat executive officer. See, he placed, my lord, before the president Ansalik.
Why
Panchayat.
there is no peon book for that?
That is maybe separated, my lord, for secretary, my lord. This is the peon book of Ansalik Panchayat, my lord.
Development block.
Yes, Ansalik Panchayat. Because record received from the Ansalik Panchayat, BDO, my lord.
What does our division man say?
I'm not aware of that as well.
We'll do one thing. We'll keep it up tomorrow, 2 o'clock.
Day after tomorrow, if possible.
Huh?
Day after tomorrow, if
No,
possible.
tomorrow. Tomorrow, 2 o'clock, I'll dispose it of. So that I can, you bring the judgment. Else, the thing is, the only way I see some ends of justice would be met is giving him 15 days for the purpose. That is the only.
I'll leave it to your lordship.
I think that is the best option.
Lordship may pass that way also, my lord.
Giving him 15 days from today, as if now.
My
So
lord.
within 15 days, he will hold it.
My lord. Lordship may pass today.
Today is 15 days will be how much?
Today
He has to hold the meeting. Today is 11th. By 26th, he has to hold the no confidence meeting within 26, failing which
Yes.
he goes.
Well.
What happens then? If he does not hold it,
Re-election is the provision.
no. If he does not hold it within these 15 days, what is the course of action then?
Stay may be vacated.
No.
Till then,
Matter is
the
disposed.
next 15 days, they will prevail. If he will not hold the meeting, they will automatically prevail after 15 days.
If, my lord, second option will be, my lord, the Ansalik Panchayat will hold the meeting.
In
As
that
per- as
case,
per section 15, my lord.
more cases will come, my lord.
No. Your only thing is this,
Sorry.
that you would have otherwise hold it.
No.
Hold the meeting if you have got the opportunity.
No.
So if you don't hold it, you have to vacate automatically.
Yes, that will be.
The stay which has been given will be operate
Next
only till
15 days on, 26.
till 26th.
Yes, that will be better.
That is the only disposed.
Right.
I'll keep the records.
My lord,
No, records you can take it. Not
Right.
necessary. We'll pass the thought.
my lord.
Records are good.
Highly obliged.
Hold the meeting. These people are now in your hands.
Yes.
Now, my lord, impugn order will go, my lord.
Huh?
That impugn resolution will go, my lord.
If you hold the meeting,
Not
that
yet.
will, that meeting will be subject to, the resolution therein will be subject to that will affect I mean, would be the order which have been the resolution, the impugn resolution will be subject to the outcome of that meeting.
Meeting.
If you don't hold it, the resolution.
Well.
I think that is the
Obliged.
only.
Yes,
win-win
yes.
45.
Obliged.
on the question of democracy. এখন very good. They dispose of for you, huh? Why to dictation? Yes.
May I please, your lordship? Today itself we have received the affidavit in opposition.
Has been filed seeking a directive and respondent more particularly to accept the payment of premium which the petitioner was supposed to pay in terms with the Iman within Iman. And going to respond and you filed the affidavit.
I filed my affidavit today itself.
When?
Today, my lord.
Mr. B. Sharma appearing on behalf of the CGSC, appearing on behalf of the NF Railway submits that he has filed the affidavit today. This is the matter again on 27th of September 2023. The registry shall bring on record the said affidavit.
46.
May I please?
Hmm.
First, this matter pertinent to expedition. Allotment two petitioner, one is husband and one is daughter of the.
Mr. Hendrik, this is 1511. Dispose of it.
Plus-
Dispose of it. 3 months. 1511 or the notice. Order 1511 notification of accident or 3 months of it.
Or 47 and 48.
Yes.
It is the law.
What are these matters?
Reconnaissance were seized
Hmm.
and they were not fit for human consumption, so it was ultimately destroyed as per the regulation of the,
You have destroyed it.
yes, Lord.
Now what is he asking for?
They are asking for compensation and declaring that the seizure was illegal.
You have filed your reply.
I have already filed my affidavit. There are another 6 matters are there.
You have not filed your reply.
My lord, they have filed reply, madam. I will not file a reply to that because I have already stated in the
So you don't need to file a reply. Okay, we'll take up disposal along with another 4 matters.
my
Give
lord.
the list of those.
We'll provide.
Huh?
Will today I have not
Okay, we'll have it after vacations.
slots.
It's a case of compensation.
Slots.
List the matters for admission on 21st of November 2023, along with
I'll give them.
an attempt shall be made to dispose of the petition on that date.
Much.
Okay.
49.
Yeah, please, Lord.
Yes.
Lordship, the matter pertains to the petitioner sought for demarcation of their land, Lordship. So the instruction is the demarcation has taken place, Lordship.
Well, nothing remains.
Yes, Lordship. So the matter may be closed.
The Land Council appearing on behalf of the petitioner submits that the relief which have been sought for relating to demarcation of the land has already been, the demarcation of the land of the petitioner have already been demarcated by the respondent revenue authorities, and as such, nothing survives in the instant writ petition. Accordingly, the instant writ petition therefore stands closed as it has become infructuous.
Obliged.
Number 59. Oh.
Yes, cognizance have been taken. What remains here?
I don't.
You will be entitled for this compensation in terms with that Assam victims compensation.
My lord.
For what has happened to the victim? He's died.
Yes, my lord. Last
As per your charge sheet, what has happened?
copy of the charge sheet is
Charge sheet has been done under 302, means the person has died.
died.
So obviously he will be entitled to compensation as per that act,
On last
Assam
occasion,
victims
lordship
compensation.
has called for that taking
That
cognizance.
I have seen it. Now cognizance has been taken
As is there.
and the next date is fixed on 12/10/2023 before that court. So that ends the matter there.
That part, my lord, quite aware, my lord, I need not to tell it in deep, but I have instructed my client, please obtain the certified copy. But we could not receive the certified copy because I was.
No. I have
please
got,
only-
no, Mr. Counsel, I have got the details.
Yes,
Last time I sought for a report
yes.
from the court. So the report says that on on 29/8/2023, cognizance was taken of offense under 365, 302, 334 of the IPC against the accused persons, 9 accused persons, and the case is fixed on 12/10/2023. So there you may take whatever needs to be done. Now regarding the compensation, the fact that you have the person concerned have died. I give you the liberty to move the DLSA.
Yes.
DLSA, it will be Huzai. We have a DLSA Huzai.
The otherwise, the foreman scheme also there, I have a next matter.
Huh?
Foreman scheme also there.
Common scheme, I don't think you will get so much. I think the DLSI,
Now,
I think it is 5 lakhs.
so far that part is concerned, my lord. This court, I have enclosed the judgment in my affidavit rejoinder, my lord. This court already enhanced
How much?
10 lakhs, my lord.
Where?
In my affidavit rejoinder, my lord.
Huh?
Respondent number 4 and 5.
affidavit was filed in the year, my lord, for the first time, my lord, first affidavit.
Where? 4.
4 and 5.
How much it is?
My lord, that the judgment has been next.
The
Kindly,
what scheme?
kindly page annexers 7, page 32. It starts. Operative portion, my lord.
Annexus 7.
Yes, my lord.
There is no
Annexure
Annexus 7 now. Where?
operative portion, my lord.
You are referring to Nilavati Behera?
No, my lord.
Then?
This court judgment, my lord.
He is referring to, I think, my lord,
Page-
annexure 7 in read petition, my lord.
Oh,
Read
no.
petition or
Page
affidavit?
43, my lord. Last page of my affidavit in Rajendra, my
Ah.
Kapotam versus state and 6 other. It is a reported case, my lord.
Oh, this person died how? How did you die? Your person, how did your person die?
My lord, I was kidnapped, my lord.
By?
My lord, it was alleged in the fire, my lord, and it, in the other subsequent representation.
No, no,
of my lord.
kidnapped by whom?
So, my lord, what I'm trying to indicate is, my lord,
Hmm?
what I'm trying to indicate, my lord, here is, my lord, regarding the, my lord, investigation part, my lord. Investigation part, and it involves Article 21, my lord. So once, my lord, there is apparently some lapses or some, my lord, negligence, my lord. So, my lord, this, my lord, judgment also might slightly help, my lord, for grant of compensation.
So there are lapses on the investigation.
Apparently, my lord, where is the person, my lord, otherwise?
Person is dead. That is what they are given.
Now, where is the victim, my lord? I mean, the victim who has been went missing, my lord, my husband. It was not recovered, my lord. Apparently, my lord, if it is charged with it, my lord.
The charge sheet is under
Person is no
302.
more, my lord. As my lord, lordship is quite aware, 107 section of the evidence, my lord. Presumption would have from at this stage, my lord, 7 years, my lord. Left, perhaps.
And in your case, when did the incident happen?
My lord, my case is in the year, my lord, 2014, my lord.
Huh?
14, my lord.
13, 12, 14, he was getting annexure phase 2, my lord. Read
After
petition.
8 years, they are coming with a charge sheet, my lord. Now.
The victim could not be recovered.
Possibly, my lord.
So you are relying on that judgment, Justice Kutesh Sosik.
My lord, there was another judgment also, my lord,
It was surrendered by Mumbai, my lord. Here in this case, my lord, there was some regarding my lord investigation part negligence my lord, has been dealt.
What is that? How much is as per 1/2/2019 notification? 5 lakhs.
5 lakhs, my lord. It was enhanced in 5.
Well, Mr. Counsel, the problem arises here.
Yes.
The state has come up with something. If we tinker here, why not others? Which have a cascading effect everywhere. With due respect here to the judgment which you have made, earlier various orders have been. I also am of the opinion that 5 lakhs is too less an amount for the purpose of the debt. But you are also have to have a look at the, unless you show categorical negligence on the part of the, which may be a case of a suit for damage, if there is a case of negligence.
Exactly.
Would you be entitled for a higher amount? Because the moment I give you here, everywhere the same thing, a person killed by an extremist, everybody will get.
Cases will come up.
Now, this is a case of 2014. I get every day a case of 1998, where there was a scheme of rupees 1 lakh. Then in 2013, they have come up, anybody killed in by way of extremist, it is 3 lakhs.
3 lakhs.
So everybody are claiming 2 lakhs each. People died in 1998. Now this is being claimed. It is about so and so. So if we go beyond this 5 lakhs, would it not lead to a far-reaching consequences? Not here. You have a right. You may get more. I can give you the liberty to file a suit for recovery of against if there is any negligence against that. But to keep a higher amount than that, because this may be taken as one of the grounds, or because our judgments becomes a question of the court of record, and it will be used as a precedent everywhere. That too, when the state, in its right earnest, have already fixed. Now, these Nalsars have a scheme. That day, I was taking up another matter. We have the Nalsar scheme. Whether the amount has become higher there. But this is the 5 lakhs which can be granted to the Assam victims' compensation. Thereby, I ask you to file an application before the AM and within 2 months to pass an award, and thereafter you get. But this will be
what Lordship is saying, with your respect, my Lordship, I agree to that extent. So far, victim compensation part is concerned. As per the Victim Compensation Act, my Lord, Assam Victim Compensation 2012, that part I fully agree. But on one hand, my Lord, what I am, my Lord, trying to throw this court attention, my Lord, with your respect, my Lord. Once, my Lord, and a case was registered, my Lord, nothing was happened initially, my Lord. When the petitioner approached this court, my Lord, upon this court interference, this or that way, my Lord, or this or that pretext, my Lord, investigation turn out. And now, my Lord, just to make an excuse, my Lord, something, my Lord, they have come up with charge. Now, my Lord, what I'm intending is, my Lord, once apparently, my Lord, there was, had it been, my Lord, of course, no doubt that they have discharged the duty by making an investigation and submitted charge. No doubt. But on one hand, my Lord, if there is, my Lord, if the state authority, my Lord, immediately swing into the matter, my Lord, that protection might have been, my Lord, sought out. The person who was found to be missing might have safe out, my Lord. So, my Lord, that part, my Lord, that investigation part, my Lord, has not been carried out in a, my Lord, in a design way, my Lord.
in a more prompt manner.
Prompt manner.
If it was done promptly, it would have related.
And we don't know, my Lord, regarding
led to a recovery even.
Yes. Regarding the consequential of the trial, we do not know. Somebody may have acquitted tomorrow. That part, we do not know. And 7 years, my Lord, only after expiry of 7 years, my Lord, now this charge sheet has expired, my Lord. Now 8 years, my Lord, 2014, we are in 2023, my Lord. And my Lord, what, my Lord, so far there is one judgment regarding, my Lord, Mumbai High Court, my Lord. It was on 3rd June 2019, my Lord. It says, my Lord, here, same case, my Lord. Victim was found missing. Later on, dead party were recovered, my Lord. And with court interference, further investigation carry out. But, my Lord, later on, my Lord, this victim has, in this case, my Lord, awarded compensation by, my Lord, Mumbai High Court, my Lord, claiming that investigation there some failure or negligence on part of investigation part. That's what this court says.
No, Mr. Counsel, then I'll do one thing.
So, Lordship,
let us then look into in this angle. I understand your point.
my Lord, I'll leave it to you, Lordship, may pass in a order, my Lord.
No. We will further hear you and give an opportunity to them. We'll hear you properly on this matter as to whether there has been any lapses in the investigation. You just show me
My
whether
Lord,
the
apparently lapse of investigation will be, my Lord, if there is no lapse of investigation, my Lord, a person would be recovered, my Lord.
Huh?
a person would have been recovered, might have been recovered.
That is a very
Ought to have
difficult
been
thing to
recovered.
say, Mr. Counsel. That cannot be the reason. You see, the investigation goes in steps to steps. They will go for these type of things. These things will happen in a particular manner. A person may not. Just for example, a person was kidnapped. At a later point of time, this person concerned was killed. You may say that if he could have been recovered out there at the time of kidnapping, he would not have been killed. But the fact that there might be many aspects of the matter for which a person may not be found out.
Exactly.
So these comes within certain laxity you have to give it. Just for example, today I am taking up so many matters. Now I am thinking that taking into account your case, I will take it up on a particular Tuesdays or Thursday so that I can give you a much better hearing on this.
Otherwise, my lord,
But if I keep on Tuesday on other days, or I do it like this, I may not be able to hear you. Isn't it? So under such circumstances also, there are in many matters. We are also dealing with 60 or 70 matters a day. It is humanly not possible
my lord.
to hear you or hear all the matters on such. The police also. You have to take note of the police also. They may not. There might be many other cases. So you may. Everybody would like their case to be dealt with with the right earnest, everything. But you also have to take a look at also the logistics, whether the police has those logistics, whether there was a deliberate attempt. If there is a deliberate attempt, yes, you are entitled to a compensation, even in a writ court. But if it is not deliberate, but it is on account of what has been, they have tried their best, can you be entitled to any further compensation? So these are various aspects of the matter we say. Anyways, I will do one thing.
Otherwise, Lordship may, without fixing the amount, Lordship may keep directing, let them examine and dispose of my lord as for the scheme, which I may be entitled.
No, you are entitled to 5 lakhs. Don't worry with that. That I'm not worried. That you will get it. That I will pass a direction, not on that. If you are entitled to more than, you show me on the next day as to how it is. Okay.
Part, let it be part.
Huh?
Let it be part, otherwise.
Partner not necessary.
Possible.
Is there to be partner. Don't keep partner. We will have it on 5th of October. You show me those, and there are various other judgments also, because you see, this is Koteswar Singh was dealing mostly with cases of leading to death in the police custody. There, obviously, you can impute negligence, you can impute human rights violations, everything. But can you impute the negligence on the part of the police authorities for not finding out the person? Although here he has stated that 3 lakhs would be too less, I give you 10 lakhs. But there's no reasons why 3 lakhs should be less. No doubt. This is a year of 12 years, 2012. 10 years down the line or 11 years down the line, the amount must have gone manifold. So under such circumstances, if it has gone manifold or even twice the amount, they are required to do it. But that they have done to fix this 5 lakhs on 1/2/2019. So that's just 4 years from the now. Now, when they have done it in their own wisdom, you also have to take note of the public finance.
Of course.
If I give you much more, yes, if you make out a case or you were able to show on a prime facie on the basis of the materials, yes, there is some laxity. There has been negligence. Obviously, this court will consider on special fact. But otherwise, it will be a bit difficult.
Sure.
Anyways, the next date is fixed out there. You need to take action.
Sure.
List the matter again on 5th of October 2023 for further consideration. Mr. Ms. M. Bormon, appearing on behalf of the respondents, shall also produce a copy of the case diary. Okay, case charge sheet.
Right.
Produce the copy of the charge sheet on the next date. It is further relevant to take note of that that pursuant to the order passed by this court on 11/8/2023, the Chief Judicial Magistrate Ozai had submitted a report before the Deputy Registrar of this court, wherein it has been mentioned that pursuant to the submission of the charge sheet in Lonka PS case number 584/2014 on 28/5/2022, cognizance was taken on 29/8/2023 under sections 365/302/34 of the Indian Penal Code. And the case, next date of the case is fixed on 12/10/2023. The say, list the matter, list according.
I'm obliged. My lord, copy.
Copy of charge sheet, my lord, it might be with the CGM Hosai, my lord, as cognizance.
Get
has
a copy of the charge sheet,
My lord.
certified copy. You people can get it. Get a certified. They'll produce the certified copy.
Applies, my lord.
63.
Hey, 42 need. Very good.
I know 50 for orders.
Here, what has happened? Allegedly for dishonor of a check amounting to rupees 8,000 issued by the petitioner, the respondent company from whom he had taken a loan to purchase a two-wheeler had instituted a complaint case under section 138 NI Act at Kolkata. Whereas the entire cause of action had arisen in Guwahati. That was put to challenge in this case.
You are paying for?
I am for the petitioner. What has happened? The address of the respondent have been taken from the materials on record. Now the report say, office note say that steps were taken. If your lordship comes to order dated 17/1/23,
Have you taken step?
I have taken step 17/1/23. I informed the honorable court.
When I have not taken step, any fresh step for issuance of notice upon respondent number 1 and 2.
No, my lord, I am indicating, my lord.
Yes.
17/1/23, there is an order of the court asking, my lord, the registry to verify that whether I have taken steps or not. On 3/8/23, there is an office note saying that, my lord, I have taken steps earlier, but my lord, the notice were returned being, my lord, insufficient address. So I have taken steps thrice, my lord, or in 2014, 19 and 20. Now, my lord, there is no other alternative, my lord, address in respect of, my lord, these respondents. Because office note 83 makes it clear that the notice has been returned, my lord, being insufficient address. Now, that is my predicament, my lord. So far as, my lord, the address of the respondent 1 is concerned, that I find, my lord, from their complaint itself. If your lordship comes to the complaint at page 20, my lord, their address is reflected therein. And this is the address of respondent 1. Now, that has been returned, my lord. Page 20, my lord, this is the address of the respondent 1. Regional office, my lord, at Kolkata. That has been returned, my lord, saying that insufficient, my lord, address. And my lord, address, my lord, respondent 2, this is their branch office at Guwahati. From the personal knowledge of the petitioner, my lord, this address has been put in the petition. Now, both the notices have been returned, my lord, saying that insufficient address. Office note, my lord, 83/23 indicates their account.
So what is wrong with this complaint?
In fact, my lord, my humble submission is that this has been, my lord, instituted only to harass me. Amount 8,000, my lord. They have their branch office here. Everything, my lord, has happened here. The cause of action, dishonor of check, issue of check,
I have taken loan, my lord, from here, the branch of it. The agreement has taken place here. Now, their regional office is at Kolkata. And to harass me, my lord, this has been instituted at Kolkata.
Are you saying that the cause of action doesn't arise?
That is not my submission.
That is your only submission that can be helped. In view of the recent the constitution bench judgment after K. Bhaskaran. What is that judgment now?
My lord, on that count, my lord, I'll address your lordship.
That
Today,
is the
my lord,
only that is the only ground. Otherwise, there is a case. And you not taking steps gives me more
No,
flexibility.
I have taken.
No. This court has directed you to take steps on 28/8/2020. You have not taken.
So that I will take steps. My lord. In fact, on the last occasion, my lord, in fact, it escaped my notice. I could not represent my lord. So give me 1 week. I will take steps.
Mr. S.K. Talukder, the learned counsel appearing on behalf of the petitioner, undertakes to take steps upon the respondent numbers 1 and 2 by 15th of September.
Well,
Is the matter after completion of steps upon respondent number 1 and 2.
Well.
It is further observed that if the steps are not taken by 15th of September, list the matter again on 22nd of September.
This is the lordship.
Hmm.
Lordship, in this case, we are directed to take steps by ascertaining the correct address of respondent number 3. But we could not take steps and we could not connect with the client so far. So we may be allowed 2 weeks time to have instruction and come back.
You have taken steps?
Lordship, we have not taken steps because we could not obtain the correct address of respondent number 3. So,
What is this OA 185?
Lordship, that is the case of DRT. But
You have stated that. Why have you stated this?
Lordship, that is.
Huh?
OA.
There's a state bank council. What is this?
Respondent number 1 is the Debt Recovery Tribunal. Respondent number 2 is the State Bank of India, and respondent number 3 is the auction.
Madam, I'll dismiss your petition on this ground itself. You can't make the State Bank of India Tinsukia as a party. What is this? Represented by the Stress Assets Resolution Center, Dibrugarh. What is this? You got to stay.
I may be allowed to call my senior then.
You do one thing, I'll fix it on next week. And thereafter, nothing doing. This is not the manner by which you get a stay of the DRT proceeding. And is the stay continuing? Yes. (2015) 8 years this has been stayed in types of address like this. List the matter again on on 18 September 2023. On which date the learned counsel appearing on behalf of the petitioner shall submit on the maintainability of the instant writ petition. The registry is directed to list the matter in the column stay vacating. Stay. The column stay. Stay will order wherein stay is there. Stay. File affidavit.
My lord, the instructions are just awaited, my lord. So you will kindly accommodate me for one further week, my lord. We are now communicating, my lord, with the Director of Accounts and Treasuries, my lord.
Lord, so for the current salary is concerned, my lord, he is getting, my lord, since November 2022 to till date,
What?
the current salary, my lord. So for the area salary, my lord, 6,41,700 is not paid.
We have communicated, specifically, we have communicated, my lord. We are just awaiting the.
The arbitration
Kindly
admits that some time may be granted for filing the affidavit in
Yes, yes.
opposition.
Right.
To list the matter on 4th of October 2023. It is made clear that if the affidavit in his opposition is not filed by 29th of September 2023, this court shall dispose of the matter on the basis of the materials available.
And so.
53.
As per the last office note, my lord,
Complied.
not yet, my lord. It appears, my lord, that this ID card or the notice has not returned till it was taken place by registered court in 2021, my lord. They are official respondents, my lord. As because this ID card has not come, returned, therefore, my lord, it has, my lord, not listed till date.
Are these people there?
Still there, I think.
Mr. R. Gustami appearing on behalf of the petitioner seeks for an accommodation for a week for the purpose of obtaining instruction as to whether the present incumbents who have been present incumbent and the present petitioners, present respondents still hold the post. Still hold the post in respect of which they have been arrayed as respondents in the instant proceedings. List the matter of the 3 weeks.
All right.
54.
On 9th of October, huh?
Right.
Yes.
As per my instruction, my lord, both the container is not in the present place of posting, my lord, and transferred to other place.
Yeah. Then you are appearing for what?
Preparing for one, my lord. He was transferred on 16/7/2021.
Contempt for what? What is the contempt?
Page 14, my lord, the order.
Huh?
Page 14,
Page 14, 18.
18 also, my lord.
What type of orders? How many orders are?
My lord, actually, one order, the
In view of the matter, the petition is disposed of with the direction to verify the service rendered by the petitioner and take necessary in regard to pay the remuneration of 49 months as claimed in the. After making this, the respondent shall release the remuneration which exercise shall be completed within 3 months from today. Okay, now tell me, when did you submit this?
my lord, to submit, my lord, the receipt, my lord, is 11, my lord. In the order itself, my lord, 22/2/2019.
Huh?
In the order,
No. When did you submit it to the concerned officials?
yes, my lord, page 11, my lord.
Where is it?
My lord, in the seal, my lord, Jilla Parishad, and receipt on 22/2/2019.
What? Page 11, annexure 1.
In a Quran.
Where is it?
Yes.
Received without a notice, without forwarding. What type of this type of petition?
And another receipt, my lord, page 15.
This is not done.
My
Where
lord,
is the forwarding?
there is no forwarding, my lord.
Who knows whom you have given? How can you arrange these people as parties out here?
Yes, my lord. There is
No.
seal, my lord. Seal is there, my lord.
Huh?
Seal also there, my lord, in the page 11.
Where?
In the left side bottom, my
Seal?
lord, Jilla Parishad.
So what?
Dhubri.
No, did you give it to these persons concerned? Against whom you have been arraying them as parties?
Yes, my lord. The Jilla Parishad, Dhubri, my lord. This is on page 11, my lord.
But in fact, my lord, the present respondent number 1, who joined as the CEO on 10/8/2020, and the this receipt, which by Allotment has shown, my lord, 22/2/2019. Thereafter, the respondent number 1 has joined. So he has been added as party. So after
No, that is okay. But the fact that whether these people have received it or not,
Office receipt.
you can't give it to anybody else. That person has to know. This is how contempt proceedings are made. You don't give it to the office like this.
Yes, my lord.
How do you initiate contempt proceedings? Is it a contempt proceeding is against an office? No.
After submission of the report to, order to
Yes.
the concerned office.
Yes, where is the forwarding?
My lord, there is no forwarding, my lord. They have received in the order itself, my lord.
No.
In the order itself, my lord, they have received.
No. Nothing doing.
service inspector respond 2, I think not completed yet.
Huh?
Service inspector respond number 2 also not been completed.
You may not be there now. What to do, Mr. Hussain?
3 weeks time may be allowed to.
I give you 6 weeks time.
The meantime, I will have the. By forwarding.
Properly
Yes.
in the name of the person concerned. Listen what order I passed.
I will.
Mr. M. Hussain, the learned counsel appearing on behalf of the respondent, a petitioner submits that taking into account that the notice that the contempt proceedings was initiated in the year 2021 and the notice was also issued on 12/1/2021. He needs to take instructions as to whether the present contemners, respondents still hold the office for due compliance to the orders passed by this court. He submits that if there are fresh incumbents to the post, he may be permitted to take appropriate steps in that regard. List the matter after 6 weeks. In the meantime, the petitioner would be at liberty to take appropriate steps. You give it by name.
Much of it.
56. Apply.
Yes.
As per the office note dated 25/8/2020.
I for what?
Service on respondent number 7 and 8 is completed.
For impleadment of respondent number 7.
7.
Yes, thereafter, have you taken steps?
Yes, Lordship.
Well, upon these new persons?
Yes, Lordship, we had taken step on 1/2/2023.
No. You want to implead respondent number 7 and 8. Okay. Now, have you taken steps upon the respondent number 7 and 8, telling them to comply with the order? The learned counsel appearing on behalf of the petitioner is not aware as to whether any notice was issued to the incumbents. Is not aware as to whether prior notice of the order seeking which is sought to be complied with was issued to the opposite parties in the instant application, for which the learned counsel for the petitioner seeks some time for obtaining instructions. List the matter. 15. List the matter after 2 weeks. I gonna. Yes.
Hey, please, your lordship, white order dated 24/7/2023 at page number 14 and the relevant para is at page number 54. Whereby I have been directed to adjust an amount of rupees 53 lakh in the loan account and to return the security documents to the rate petitioner as well as the respondent opposite party.
Where's the direction?
That is relevant portion is at page number 54. And judgment starts from page number 14.
Then a paragraph.
Paragraph number 32, your Honor. And the last,
Don't you think this matter should come up before Justice Manish Chaudhary?
yes, your Lord, yes.
Taking into account that the order pertains to the order has been passed by the order wherein certain additional directions have been taking into account the scope of the instant application, whereby which certain additional directions have been sought for in respect to the judgment and order dated 24/7/2023, passed in WPC number 4484/2021 by Honorable Mr. Justice Manish Chaudhary. This court deems it proper that the said application, that the instant application be listed before the said court.
Can I pray for a date? Can I pray for a date? Or week?
The registry shall, Mr. M.K. Chaudhary, the learned senior counsel appearing for the respondents.
Writ petitioner?
Opposite party, appearing on behalf of the opposite party writ petitioners. Expresses urgency in the matter. The registry shall duly list the same at the earliest.
64.
Yes.
May kindly adjourn the case for today.
Huh?
Lord, may kindly adjourn the case.
Okay. Why?
The senior counsel BDS is not keeping back.
Okay. This is the matter of the 4
On
weeks.
Lordship, there is an urgency. Lordship, then IA for amendment of the restriction on 24/11/2020.
I allow that I,
Amendment.
what do you say? That's it. Oh, that day this matter came up.
My lord,
I remember.
whereby
Huh?
it has been challenged.
Yes.
There is appropriate alternative remedy.
Land is allotted by the Development Authority in the name of petitioner's husband. And he paid premium, all the premium. After that, petitioner husband died, then petitioner came before the authority to change the name in her name. But without considering.
Could it change the nature and character of this writ petition?
My lord, actually, after going to challenge, my lord, sell the.
So they may challenge even the what do you call that? What do you call that thing which had landed in the moon? Chandrayaan. They may challenge that also. They may challenge Chandrayaan also. But whether it is maintainable.
My lord,
That is another.
that is no, not. That is my,
But would he change the nature and character?
my lord, in that aspect, my lord, my submission is that, my lord, then it will become, my lord, a private dispute. And
That is very good for you.
my lord, then,
Your submission becomes more better when the writ petition is brought in.
no, my lord, then the civil court will be proper forum, my lord. for-
Are you the petitioner?
No, my lord, I am the respondent number 4, my
So why are you helping the petitioner?
my lord. So it is not maintainable, that is my.
So let the matter be amended, then let it be pending for 4-5 years.
No,
And then in the meantime, the sale deed can't be challenged later on in
my
view
lord,
of the
there is a-
limitation.
Here is another ground, my lord, the limitation is also there, my lord.
Understood, their limitation. Sale deed is in your
Like,
favor.
If, my lord, the amendment is allowed, my lord,
So
then, my lord, limitation period will be waived, my lord,
will be
waived, my lord.
how?
My lord, because if this court, if this court allow to challenge the sale deed in this present petition, thereby allowing to challenge, my lord, the repetition in this present proceeding. my lord. And my submission is that, my lord, that in this proceeding.
But
that
Mr. Counsel, tell me only one thing. They may ask many things. That I can dismiss in the writ petition. But can I dismiss it here on these things? They will.
No, my lord. Another ground is that, my lord, hereafter, after sale deed, my lord, mutation was granted. Hereafter, my lord, severed patta was granted. And that was in the year 2016, my lord. And we have filed our, my lord, counter affidavit, my lord, in the year 2020, my lord. And they are 2018, my lord. They did not challenge. Yeah.
You want to say that if I bring in this now, by operation of the doctrine of relation back, it will go back to the date of filing of the writ petition. And in effect, then they will get the benefit under 14 when they file a suit. You have put it on your affidavit, these aspects, or are you making this submission?
Perhaps, my lord, not clear. But, my lord, but even, my lord, if this LDD is allowed to be challenged, my lord, they are not going to challenge thereafter the consequential mutation and, my lord, the separate patta issued by the authority, my lord. That will remain, my lord, thereafter also.
You have not got your patta.
I have got, my lord, the separate patta has been, my lord, allowed.
What is your problem? You should be happy.
My lord.
You should say that this is a very important issue involved. And as such, this court should issue rule and admit this petition. So the next 15 years, you can sleep. They can't file
No,
a
my
suit.
lord, the stay is granted, my lord, and it
Stay for
operates
what?
against me, my lord.
Stay for what?
My lord, the municipal authority already granted, my lord, my lord, to permission, my lord, to erect the wall, boundary wall.
Then?
And that is stayed, my lord, already.
Have you filed an IA for vacating? File it. If it comes before this court, I'll vacate it. What is all this stay? As regards the municipal granting a permission, this is absolutely within the ambit of a civil court. You have not filed. What to do? Can't help it. Yes. So we adjourn it today. I would have adjourned it today and dismissed the petition.
Kindly fix the meter on Thursday, Lord.
What?
Thursday.
Sorry. Thursday, these type of matters. No. This type of matter. Thursday has to be matters of something has to be substance. Let's this matter be listed again on 27th of September.
65.
Yes.
Respondents are required to file an affidavit.
Huh?
Respondents are required to file an affidavit.
Yes, you file affidavit.
My lord, the affidavit has not been, otherwise, my lord, rule is very clear, my lord. It has been amended. The minimum qualification for holding the higher post which the petitioner is taking, that qualification he doesn't have.
Has it been reverted to number 4, grade
Yes.
4 now?
Yes, my lord. He is a private respondent. He never appeared before the court, my lord, placed his case. Now he has preferred the review after, my lord, the order was passed. And being a court of equity, my lord, of course, my lord, if the petitioner is not entitled for not having the qualification, the private respondent also cannot enjoy the, my lord, benefit.
No, he's
Ground
senior.
for, my lord.
Petitioner is senior.
No, seniority is not the issue, my lord. The
If the qualifications are same, then petitioner becomes better.
no, my both doesn't have the qualification to hold the, my lord, promotional post.
Understood.
Yes.
Let us assume what he says is that graduation is not
In
required.
that case, he will get.
Ah.
Lord has rightly said. If
That
at all
is
he
what I am
entitled,
saying.
then the petitioner will come.
Ah. So that is it. Anyways, let's keep that person in grade 4 for some more time. You file your affidavit,
Lord, sir, I-
4 weeks time grant. This is the matter after 4 weeks. In the meantime, the Finance and Taxation Department of the Government of Assam shall file their affidavit. File their affidavit in opposition to the review application without fail. This is the matter on 8th of November.
Obliged. Lordship, I beg your intervention. Lordship, item number 55.
What is it?
I'm for the respondent for the Cooperation Department. Adjournment has been sought for before this honorable court and we have not been informed, your lordship.
55, 56. Oh, he said that he has taken information.
No, your lordship.
Previous occasion also, he have never informed us.
Hey, in the morning, I said no. Because you have not informed. At 2 o'clock, he informs this. That
No,
I have
not
informed
misstatement,
and
yes.
then I have done.
Okay.
There's no urgency in the
Yes.
matter. Rather they are the petitioner, they are seeking refund of their money, alleging. But they should at least inform us, my lord. We are keep waiting.
No, I made it a point. I, in fact, didn't grant him an adjournment in the morning. Anyway, when did I fix it? 2 weeks. Is there any stay?
No.
The matter will be 2 weeks.
All right.